Morning, everyone. I would like to extend to you a warm and cordial welcome to our last day of our second international workshop of the Network of Philosophy of Private Law held at the Externado University. We hope to close this important academic space with a flourish. Today, we will have two lectures, one by Professor Arthur Rifstein, entitled Public and Private in the Law of Public Nuisance, and the other one by Professor Diego Papayanis, titled Unequal Private Law Under Distributive Justice's Watch. We will end international workshop with a balance of the events and some closing remarks by Professor Alexander. Professors Ripstein and Papayanis, thank you very much for your participation in this workshop. On behalf of the External University, we are very pleased to have you here. Without further delay, we will start the second day of our international workshop with the lecture Public and Private in the Law of Public Nuisance by Professor Arthur Ripstein. Professor Ripstein has an MA from the University of Pittsburgh, an LLM from Yale Law School, and a PhD from the University of Pittsburgh. He is currently Professor of Law at the University of Toronto. Professor Ripstein's research and teaching interests include torts, legal theory, political philosophy, and Kantian philosophy. In addition to numerous articles in legal theory and political philosophy, he is the author of Kant and the Law of War, Rules of Wrongdoers, Private Wrongs, Force and Freedom, Kant's Legal and Political Philosophy, and Equality, Responsibility, and the Law. Professor Ripstein, thank you very much for your presence. I give you the floor.
Thanks very much. It's an honor to be here, and I want to begin by thanking the organizers for inviting me. And I have, over the years, had many elevated discussions about private law, but never at such a high elevation. So that's an extra delight. What I want to do today is talk about the tort of public nuisance, and I'm particularly interested in the way in which public and private aspects combine in it. Every tort action has a public aspect to it. It's brought before a court. It is tried under laws that are the laws of some particular jurisdiction or other. And then there's another way in which there's a lot of overlap between tort and public law, which is that many crimes are also at the same time torts. For example, the crime of theft is the tort of conversion. The crime of battery is the tort of battery, and so on. But there's a different way in which public and private interact in the tort of public nuisance, and that is my main topic for today. One of the things that is distinctive about public nuisance is that the rights that are at issue in public nuisance are rights that are fundamentally public in a way that I'm going to explain. One way of seeing the implications of this is that public nuisance has doctrinal features that make it very different from other kinds of tort actions. The one that's perhaps most conspicuous in the literature is the fact that in public nuisance, apparently a plaintiff can recover for what would be treated in other tort actions as pure economic loss. Let me give you an example of this with the English case from 1983 of Tate and Lyle versus the City of London. London had built a ferry terminal on the Thames. The Thames was authorized, that ferry terminal was authorized by statute, and it was understood that the building of the ferry terminal would cause a certain amount of silting. Tate and Lyle, which is a sugar company, had two jetties, one for raw sugar, one for refined sugar, and they silted up and required regular dredging as a result of the building of the ferry terminal. Because of this, Tate and Lyle incurred expenses, and so they sued the London Council in order to recover their economic losses. They sued both in negligence and in public nuisance. Their suit in negligence failed at the House of Lords. It was defeated on a motion to strike on the grounds that they had failed to state a cause of action. Why? Because, as the House put it, they had no right in the riverbed, as a result of which damage to the riverbed was not actionable in the tort of negligence. They had not suffer damage to anything that they owned. Their jetties were perfectly intact. They didn't own the riverbed. And so their loss was pure economic loss. But the House continued. They were nonetheless, the city was liable in public nuisance. Why? Because the Thames is a navigable waterway. As a navigable waterway, Tate and Lyle, as a landowner with land abutting the navigable waterway, had an entitlement to the usability, that is, the navigability of the waterway. And the building of the ferry terminal through its excessive silting had interfered with that. And so what was economic loss for purposes of the tort of negligence was not economic loss for the purposes of the tort of public nuisance. So this raises a series of interesting questions. And these questions are the ones that I will focus on today. The first of those is a question about who it is that is wronged in the violation of a public right, such as the right to the navigability of a navigable waterway or the passability of a public road, or various other examples that I will mention towards the end. So we can call that the question of outstanding. The question of outstanding has a special force because public nuisance involves public rights, rights that have, in a sense, I will explain, a structure as rights that every member of the public has. But then there's a question, why is it that this particular plaintiff gets to complain? There's also a question about what it is that the particular plaintiff is complaining about. In one sense, it's clear, the silting of the riverbed, for example. But in another sense, the question is, what's wrong with the defendant's conduct? So we have a question of outstanding. We have a question about the nature of the wrong. These two questions come together in a feature of the tort of public nuisance, which is called the special damage requirement. In order to sue in public nuisance, the plaintiff needs to show that they suffered special damage. And I will say a little bit about the specialness of that special damage. And finally, there is the question of why it is that there is a seeming exception to the supposed exclusionary rule for pure economic loss. So those are the problems that I hope to explore with you today. Let me begin then by just drawing your attention to the way in which I am thinking about the law of public nuisance and the law of torts more generally. Now, of course, I know that I was invited here because everybody knows what I think and that I am. I once gave a talk at NYU, and afterwards Tom Napier said to me, you know, over the years, we've had lots and lots of speakers who describe themselves as Kantian, but you're the only one, you actually mean it. And so I have the most extreme Kantian. One way of characterizing the extreme Kantian view in the case of the law of torts is that the law of torts is exclusively concerned with transactions between persons. And so, as I always act it out for my students, the plaintiff comes before the court, points at the defendant and says, the defendant is not allowed to do that to me. And the defendant comes and says, who? Me? What did I do? And the entire focus of tort litigation is on the plaintiff's claim that the defendant did something to the plaintiff in particular. It's all about the particular transaction. If we think about tort law in terms of the particular transaction, we can see why, as a general matter, there could be no liability for economic loss in the tort of negligence, for pure economic loss. If I damage something on which you depend, but which you do not own, I haven't done anything to you in the relevant sense. I've done it to the owner of that thing. So too, if I breach a contract with someone other than you, of course, I have committed a wrong against the person with whom I had the contract. You may suffer losses, but I haven't done anything to you, because we always look exclusively at the relation between the parties. But that means that the standard cases of economic loss, and again, we can bring in Tate and Lyle, if you don't own the riverbed, the fact that I damaged the riverbed allows me to say in response, what? Me? What did I do? Because I didn't interfere with any right that you have. Now, in thinking about the tort of public nuisance, my focus will have to be on explaining what it is that the plaintiff has as a matter of right. And once we understand that right, we will understand standing to sue, we will understand the special damage rule, and we will understand why, in cases of economic loss involving public nuisance, this is not pure economic loss, but is instead actually consequential loss. And so we will get a further vindication of the Kantian view, which I take to also be just the traditional legal view, that law is about a transaction. And we will get a further repudiation of the functionalist view that the point of law is to provide people with incentives to behave in ways that are economically efficient. My friend Kathy Sharkey, who teaches torts at NYU and writes about public nuisance, says, as a matter of doctrine, it can't possibly make a difference whether the plaintiff sues in negligence or in public nuisance. To which my answer is no, it makes all the difference. So what is the right that someone has? So I've written about this at length before, but let me give you a simple version of the answer, or a simplified version. The answer, perhaps not simple. The paradigmatic case of a public nuisance is the blocking of a public highway or a navigable water. That is the traditional case in Roman law, the traditional case in the common law, traditional case in civilian systems. The basic thought is that members of the public have a right to pass and repass on a public highway. And the wrong of public nuisance is an interference with that. Now, question, why is that a public right? So here's a way of thinking about it. Roads are a legal solution to a fundamentally legal problem. The fundamentally legal problem is that if you have private ownership of land, where private does not necessarily mean individual, the land could be owned by collectives, the fundamental feature of ownership of land is the right to exclude others from your land. But that means that every owner of land is fundamentally landlocked by all of their neighbors. If you want to leave your land, the only way that you can do so is by going through someone else's land. But your neighbor is entitled to determine whether you can use their land, which means they're entitled to determine whether you can cross their land. And so there is a systematic problem of people being dominated by their neighbors. This problem is not in any way cured by the fact that it is everyone's problem and everyone suffers it to the same degree, although there may be, in a certain sense, a distributive equality in this predicament. It is a non-rightful distributive equality. So what's the solution? Roads understood as public rights of way, so that each person can get from any location to any other location without requiring the private permission of any other individual human being. A road exists juridically as a system of rules of access, rules for contributing to upkeep, and so on. And from this abstract idea of what a road consists of, namely as a public right of way, that members of the public are required to maintain and that members of the public are free to use for the exclusive private purpose of passing and repassing, gives you the concrete things that we think of as roads. That is, they are the things on which you have these rights. These rights are correlative to duties on the part of everyone else. That is, you're not allowed to block the road. You're not allowed to use the road for a purpose other than passing and repassing on it. And of course, there are de minimis exceptions. And so as you're getting in and out of the taxi, of course it can block the road temporarily. But what you can't do is use the road for any other purpose. In the written version of the paper, I have a brief description of a wonderful case from Australia from 1952, in which a farmer plows up a dirt road and plants crops on. And that is obviously unacceptable. Why? It is an interference with the right of members of the public to pass and repass on the public road. It is also something we could describe, and it's particularly vivid in this case, as an inappropriate privatization of the public right of way. Why? Because on the one hand, there is a willful interference, but even if it's not willful, the fundamental point is that they are interfering with the availability of the public road for others to pass. But that means that each of us has a right to pass and repass on the public road, which then raises the question, is that a public right or is it a private right? To which the answer is, it's both. How are we to understand it as being both of these things? It is a public right because it is a right that does not depend on any affirmative act on the part of the right holder. It's a right that everyone has simply in virtue of being an inhabitant of the jurisdiction. It's public in the further sense in that it depends on this system of public infrastructure. It is not something that could be conceived in what in the 17th and 18th century was described as a state of nature. Because in a state of nature, there, on the content view, no enforceable property rights, and so there is none of the problem to which public rights of way are a solution. So it is a right that you have. You have it in a certain sense, not merely against the public authority that needs to provide for the road, but also against every other user of the road. That is, every other user of the road needs to do their part to leave the road in proper condition. Sometimes that means paying taxes towards maintenance of the road, but notice stopping at traffic lights, going the speed limit, and so on, are also assigned parts that we have in the system of social cooperation that constitutes the existence of the road as a legal thing. So that's where the right is. Next question, the question about standing. Who is it that has standing to sue and why do they have standing to sue? Because you might think, and you would be right to think this indeed, that if I wrongfully privatize the road, I commit a wrong against everyone. I block the road in Bogota and everyone is prevented from getting to their destination. Of course, there are some people, for example, the members of my family back in Toronto, who are not really inconvenienced by this because they weren't planning to use the road anyway. But the question is, if what's wrong with my action in blocking the road is that I'm failing to do my part within a system of social cooperation, why do you in particular have a complaint about it? Why isn't this just a public? So the way that the law has developed in the common law world to deal with this is by imposing a requirement of what they call special damage. The special damage requirement has mostly been consistently developed over the past 4 centuries, though there are a few cases where there was a brief period in the 1970s through the 1990s where it kind of went off on a detour. Let me say something about what's wrong with the detour, and then I will explain how it is properly understood. The detour consisted in the thought that something counted as special damage if it was different in kind from the damage suffered by other people. But that means that if the road became unavailable, well, it was unavailable to you and you couldn't get to your destination, but it was unavailable to everyone. So therefore, there wasn't. That can't be the right picture. Why can't that be the right picture? Let me illustrate with a story about the American philosopher Sidney Morgenbesser, who was once called for jury duty in New York. The prosecutor said this was a case involving police brutality, and in order to make sure that Professor Morgenbesser was not going to be a biased juror, the prosecutor said, I have just one question for you, Professor Morgenbesser. Have you ever been treated unjustly or unfairly by the police? Professor Morgenbesser said, Unjustly, yes, but not unfairly, prosecutor. What does that mean? Well, it was during the riots at Columbia in '68, and a police officer, I was standing there minding my own business, and the police officer came along and hit me over the head with his billy club. That was unjust, prosecutor, but not unfair. No, it wasn't unfair. He was doing it to everyone. Of course, the point is, it does not cease to be unjust because it's fair. The fact that I'm blocking everyone doesn't mean that I am not wronging you in particular. And the fact that I'm wronging lots of people does not mean that I'm not wronging any one of them. It can't be that your right is contingent upon my not wronging someone else the same way. Otherwise, of course, an opportunistic wrongdoer could generate a permission for themselves by just wronging multiple people. That's not it at all. How are we to understand the special damage requirement? The key is to think about the way in which the right operates in the tort of public nuisance. Because the right is a right to use something. It's a restricted right to use something. You can only use it for the purpose of getting to your destination, even if your destination is just going for a walk or a drive. But if there is an interference with use, we have lots of law about that in the law of private nuisance. The leading case on this is actually the case of Sturgis and Bridgman, a case that has generated a lot of literature because Ronald Coase treated it as paradigmatic for making a point about transaction costs. But in fact, the case isn't about transaction costs. The case is about easements. And the case is about easements because it is a case involving a confectioner and a doctor who were neighbors. The confectioner had machinery that caused noise and vibration. The doctor built a new consulting room, and the noise and vibration from the confectioner's machinery interfered with it. The doctor sought an injunction to stop the noise and vibration. The confectioner said, I'm entitled to an easement. I've been operating this for 20 years without a complaint. And the court said, without deciding whether you could have an easement for a nuisance, you couldn't have an easement for a nuisance in this case. Why? Because for those 20 years before the doctor built his consulting room, the vibration was not a nuisance. Why? Because it was not an interference with the physician's use of their land. But if it wasn't a nuisance, then you can't get an easement because the physician couldn't have gotten an injunction. You can only get an easement for something that the other party, the servient tenement, was entitled to prohibit, but couldn't have gotten an injunction because there was no nuisance. What does this show us? It shows us that the core of a nuisance is an interference with use, not with possible use, because of course there was, as it were, a notional nuisance right from the start, but rather an interference with actual use. Let's go back to the road. So if you were driving on the road and I block it and you have to take a detour, or one of the earliest cases, you were using a navigable waterway and I blocked it and you had to carry your goods by land, I'm interfering with your use of the thing to which you have a right as a member of the public. On the other hand, everyone else, I'm only interfering with notionally. But if I'm only interfering with them notionally, then there is no wrong that is personal to them. And so they have not suffered special damage. Once we understand the special damage rule in this way, we then get an explanation of the third thing that I said I was going to explain. That is why there is recovery for economic loss in cases of nuisance. One of the early cases, the canal blocking case I just mentioned, is called Rose and Miles. The plaintiff in that case had to move his goods by horse and cart rather than through the canal. Because he had to move them by horse and cart rather than through the canal, he suffered economic loss. His goods were not damaged. They were in perfectly good condition. His loss was purely economic. However, he was entitled to recover because his losses were consequential on the violation of his particular right. Once we understand that, we can then understand how there can be recovery for pure economic, what looks like pure economic loss, without being a violation against the supposed bright line rule against recovery for pure economic loss. Because there is no such rule about economic loss. There is a rule instead about rights. The plaintiff can recover for a wrong that is personal to that very plaintiff. If you're entitled to recover for a wrong that's personal to you, then you are entitled to recover consequential damages for the wrong that is personal to you. What I've tried to explain is that in the tort of public nuisance, although the source of the right that you have sounds in public law, that is in fundamental conditions of sharing a legal order and fundamental terms of social cooperation, and although the wrong side sounds in those same public things, that is in the defendant's failure to do their part in such a system of social cooperation, nonetheless, the wrong is personal to the plaintiff because the system of social cooperation is a system of providing for the conditions in which something is available for everyone to use. Once we understand that someone in particular can be wrong, and we understand further that they can recover for the costs that they incur as a result of them having been wrong. Let me just conclude, I think I have about a minute left, by saying something about, as it were, the second life of public nuisance, because of course public nuisance has taken on a life of its own throughout the common law world in the last couple of decades. And in the US, it has taken a peculiar form of being asserted in multiple cases and virtually never successful, because it's taken the form of levels of government with no power to regulate something, suing people who have created a problem for it. And so there was public nuisance litigation about lead paint by cities. There was public nuisance litigation about guns by cities. Cities, obviously, putting aside the US's crazy Second Amendment, wouldn't have had the power to regulate firearms anyway, but they said, it's the cost. And so too, with respect to opioid litigation. And in every case, what they've tried to do is say, aha, public nuisance allows recovery through pure economic loss. We don't need a right. Those cases have not gone very far. Here's the more, why is that? Because they didn't identify a right of members of the public that was violated. They simply identify a loss. The other place where it has found, I think, a more promising home is in other common law countries, most notably New Zealand. Full disclosure, the barrister for the plaintiffs in the Fonterra and Smith case in New Zealand was my doctoral student, David Bullock. There, he successfully argued public nuisance, and this is a climate change case. The public nuisance consisted in a special damage suffered by a particular member of the public through the wrongdoing of the particular defendant. Lots of doctrinal detail required, and he's merely prevailed on a motion to strike. But the key point is that there's a genuine legal issue because there's a right. Because, coming back to why you invited me, that's what tort law is all about. Thank you.
Thank you very much, Professor Richardson. for this great lecture on such an important and discussed topic as public nuisance. We will now begin the discussion with any questions that our attendees may have and they wish to ask direct to Professor Ruiz.
Earlier versions of it, very hard. And
You caught it, but it obviously hasn't learned anything.
I always think it just pull you a little direction. But first, I'm going to shame within it two comments that possibly two questions. So one comment is, I think that the American public nuisance thing is stranger than you think, because what happened is the tobacco industry settled for $250 billion, which is not most people's ideas of not very successful. They gave me $250 billion. That's pretty successful. But what's strange about, and even the opioid litigation is in the billions in settlements already. Maybe not, there's hundreds of millions, but it's pretty significant. And what's strange, there are some successful cases like lead paint in California actually succeeded. But what's strange is that you're not getting, and the parties don't seem to want adjudicated rulings. So in one of the opioid decisions, the case was settled on the basis of an intermediate appellate court ruling. And when the Supreme Court ruled, which was in favor of the plaintiffs, and the Supreme Court ruled against the plaintiffs, they did not upset the settlement. So what you're getting is a rather striking version of a kind of libertarian private government by contract, where the states, instead of regulating, are working out tort lawsuits against the defendants, instead of letting the legal system settle it for them, settle it with private contract. It's really quite remarkable. But that's just a comment. The second comment is, although I know you love your Oregon message story, you want an example of the special injury rule working in its very peculiar way, which I don't know that it's a thing of the past, but the case is the Exxon Valdez case. In the Exxon Valdez case, which is this vast oil spill in Alaska, ecological disaster, the public nuisance claims, private causes of action for public nuisance were brought. One was by fishermen. The fishermen recovered because of pure economic loss. Another was by a native tribe that was devastated because their entire way of life depended upon the natural resources and access to the waters in that bay. And if they didn't recover because too much damage, okay, and also it wasn't different in kind. It wasn't really any different from, say, Greg flying up to Los Angeles to go wandering around Alaska for recreation. So the party with the much more severe harm, because they were devastated for the duration of the oil spill, did not recover because their injury was not sufficiently different in kind, whereas the party with the more trivial harm, pure economic loss, they have serious harm if they're fishing with the pollution, but less than the tribe did recover. And I think that is the paradox that I think it's Newark people complaining about. So just a thought, if you want to use it for an example. But here's now I finally worked my way to a question. So there's a leading American case called One Meridian Plaza, and it involves a fire in a skyscraper in Philadelphia. It takes something like a year, I don't know exactly, to repair and rebuild the skyscraper after the fire, and lawsuits ensue. And one is a public nuisance lawsuit. And the public nuisance lawsuit is because in order to repair the building, they have to close the block so that everybody has to route around that block. And you can imagine different kinds of claims whose rights have been interfered with. It is the quintessential original core public nuisance example, interference with the public way. And there are people who commute and go by foot past that building. Now they have to reroute. So every day coming to and from the office, they're detour a block to get to their destination. And those people did not recover. Although I think intuitively we would say, well, they did have an actual right interfered with. It's not like your family in Toronto and traveling in boats. It's actual interference with your community. But they didn't recover. They were held not to have special injury. just to have to lump it as either their injury is, I think courts always help themselves to every reason they think favors them. So throw in, it's just inconvenience. You should lump it. And it's just part of the general interference that the public suffers. It's not special. You don't get to recover for it. If there's a cause of action that protects it, it would be some kind of public cause of action. But who did get to recover was the shopkeepers on the first floor. And the court certainly cited public nuisance doctrine as an exception to the pure economic loss rule, because it said, the shopkeepers didn't suffer damage to their property. It's just that they're out of business for a year. So they get no customers, but they didn't have rights to any particular customers. What they suffered was an acute pure economic loss. And so in that example, pure economic loss, it's very hard to call it consequential damages. The reason it's hard to call it consequential damages is it seems in describing it, we should say everybody who had to detour a block to and fro on their way to commute to work actually had any interference. They weren't the people who could have theoretically used but never did the public road. And so too did the shopkeepers. But the shopkeepers get a cause of action because they suffered a serious pure economic loss that counts as a special injury, whereas the inconvenience to the commuters just isn't enough. So the test of the violation of the right in that case is pure economic loss, and it's consequential damages. And so I think you would take the position that the pure economic loss rule, the exception to the pure economic loss rule, the way it's understood, actually defines the interference that counts as a violation of the right, or a case like Meridian, which is a standard American case. That is the standard American understanding of the pure economic loss. Of course, you can always say, praise the Second Amendment, but I just don't think you can square it with the view that that's consequential damage.
Okay, so thank you for all of this. So I have a footnote early in the paper in which I talk about why I'm not going to talk about the American cases in detail. And at the end of the footnote, I refer to my colleague Ernie Weinrib's paper called Can Law Survive Legal Education? And it is, I'd say that in response to some of the twists and turns of American public nuisance cases in particular. I think that the Exxon Valdez case, the Fishers recovering, that's just the traditional rule. Why? Because one of the traditional common law rights that you have is the right to fish in tidal waters. You have that as a right as a member of the public. You don't have it as a private right. And so there is an interference with the right to do that. And in the same way that you, in addition to having the right to travel on a navigable waterway, if you have land that abuts the waterway, or if you are a licensee for land that abuts the waterway, you have a right as a member of the public to abstract water from that waterway. And all of that is a matter of the rights that you have as a member of the public. I actually think that the indigenous group to which you refer had a similar kind of right with respect to the features of the natural environment. And so I actually think that that case is just wrong. And I mean, that's one of the great things about having this extreme content view. I think just the next cases are wrongly decided. But the point is that they were asserting a right. And it was a right that is common to members of the public. And indeed, my recollection of that case was that part of their right involved fishing. And it was only the commercial fishers who recovered because the court mistakenly thought that in order to recover in public nuisance, you had to show economic loss as opposed to showing other kinds of loss, and they didn't treat it as economic. About the One Meridian case. So one of the issues that comes up in public nuisance that on which common law courts have divided is whether those with property along a public road have a right that their customers be entitled to pass and repass on the public road, or instead only have a right that they themselves do, that only the customers do. My own view is that it is the people who use the road who have the right. Now, there is, of course, a claim in private nuisance if someone denies you access to your own land. And if someone denies you access to your own land, then you might have an action there. But I think that the cases that say, oh, it has to be economic loss to be recoverable, have just misunderstood the traditional doctrinal structure. Now, of course, as a Kantian, I also think that the law it requires institutional existence. And so I'm not saying that the United States is not kind of free to go off on a detour of its own about these matters. But my point is that the traditional law of public nuisance has this sharp distinction and does not treat it as a matter of economic loss, but instead treats it as actionable only secondary to the violation.
Thank you. Really fascinating continuation of your thoughts on public uses. And I think my question is not about doctrine or how cases are to come out, but rather the implication for 21st century society from your metaphor of public roads. It seems to me that if you're right, it's a very important condition of life that one needs to be free from being landlocked and be able to travel. Does that not mean that the government, rather than private providers, should deliver and furnish electronic technology for communication? Isn't that the 21st century extension of metaphoric stretch on public roads that are geographic, literal?
So that's an interesting question, which you might not be surprised here. You are not the first person to ask me. And I think that the answer is we need to be quite careful in distinguishing several different questions. So I think that the idea that there are rights that people have as members of the public is certainly not restricted to public roads, nor I think is it restricted to even natural resources and so on. And so it may well be that the key right in the context of communication is that you have a right that no one be entitled to interpose themselves between you and those with whom you wish to communicate, assuming the others are willing recipients of your communication. And so all of that seems right. And so it seems like there is a way of extending this characterization to cover that case. However, notice that that's not the same as the question of who is going to provide the relevant infrastructure. Let me illustrate with one of the implications of this view is if we think about the nature of public roads, we actually get a characterization also of the nature of public accommodations. And going back to Roman law, there was a law, the law of innkeeping in Roman law, basically said the innkeeper needs to take all paying customers, assuming there's room at the inn, but does not need to accept anyone as a long-term resident. Instead, what the innkeeper is, and the same thing applied to ferry operators, is a node in the system of public roads. Now, of course, the innkeeper is free to go out of business. What the innkeeper has to do is, if they function as an innkeeper, take everyone in. So too with common carriers. So too, it seems to me, with communications carriers. And indeed, the same rule for innkeepers actually applied, again, beginning in Roman law, to public markets. Everyone was entitled to buy and sell in the public market square. And my own view that this is kind of another thing as part of a larger project. I know it's always cheating to say, oh, this is part of a larger project, but I actually think anti-discrimination law has its origin in this same kind of picture of rights that we have as members of the public. And the development of anti-discrimination law comes out of the way in which we have come to recognize that more and more of society is like a public open market. But in the same way, it seems to me clear that internet service providers and various other intermediaries, like these various platforms that I don't use, are occupying this public space in a way that, just as the innkeeper on the one hand can be in it for the money, but on the other hand is not entitled to say, it's up to me, I have the right to exclude, so too with these various platforms. And also, I think there are interesting questions about the extent to which they are entitled to monitor what's going on. And we had a talk a few weeks ago about privacy, and someone was talking about how Google knows all of these things about your personal life. And I have this great example of Google, their algorithms, I just messed them up because I was working on this project that required me to read a bunch of 18th century German legal documents. And on Google Drive, you can click translate, and so you can translate from Gothic German to Roman German, so you can read it quickly. And so it recorded that about me. And after that happened, I started getting ads for heavy yard work equipment. At first I thought they were sending me all these things from wood chippers. At first I thought it was because I had recently viewed the movie Fargo, but that wasn't it. But the point is, should they be entitled to do that? And the answer is, they're providing a service to members of the public. You're right as a member of the public not to be subject to anyone's private choice with respect to your availing yourself of those things. It has to be the right way to handle it, but saying that has to be the right way to handle it is of course not. Okay.
Thank you, Professor, for your exposition. It's hard to disagree with you, but
People manage.
I have a question. What do you think if I say that somebody can be special damaged without being deprivated of the use of his right? And what I'm thinking, and I'm thinking in cases in which somebody put at risk to other person. And when you was speaking, and I remember this article in the Civil Code, Colombian Civil Code, and the article 2359 that says that when a building is close to collapse, anyone in the town have the standing to sue the owner of the building to prevent the collapse of the building. But if someone is especially put at risk for that collapse, only that person has the standing to present legal action against the owner. Yeah. So that is not a deprivation of the use of the land, neighborhood, close to the building, but it's a position that is a normative force to give another use to his land, for example, to take precautions or something like that.
Okay, excellent. Thank you so much. Please email me the details of that section, because you said it was hard for you to disagree with me, and let me just explain to you why you're not disagreeing. So there are lots of common law cases like this too. And so, for example, if someone there's a case in which people have been throwing garbage into an empty lot and it smells terrible and it becomes the road is not impassable. It's just that the road is unbearable, and so no one can walk by. No wrongdoing on the part of the owner of the vacant lot, but rather there is an interference with the availability of the road. Now, how does that differ from your case? And the answer is, it seems to me it's the same case. That is, anyone can complain to the authorities. This is in danger of blocking the road. Why? Because that's just people informing the authorities of something that is an imminent threat to the public availability of the road. But now, the way that I would understand, and again, obviously, I haven't read it and I don't know the rest of the doctrinal structure in which it's situated. But the way I would understand the special damage rules operation here is exactly the same as the way in which I would understand the role of a quia timid injunction in a private nuisance, which is to say there will be cases in which, although the tree is not yet fallen on, or the infestation of animals in the tree or in the decrepit house hasn't yet infested my house, but I see it's going to happen, I'm allowed to do that. The health department can do that. And anyone else can call the health department and say, look at this house teeming with raccoons. You got to do something about it. But only I can get an injunction. But it seems to me that the same thing is true. I am the one whose way would be blocked. And so this is where it is genuinely imminent that it is about to collapse. That in that situation, I am entitled to an anticipatory injunction because I am the one who, if the building collapsed, would be entitled to claim in public nuisance.
Okay, now, in strict sense, you don't need the deprivation of the use of the right.
No, but it is, but okay, but again, let's do the analogy with the private nuisance case. My right has not yet been infringed when I successfully get a quia timid injunction. Instead, my right is about to be infringed, and what I need to establish is that my right, I need to establish on a preponderance of evidence that my right is about to be infringed. And so I can require my neighbor to abate the nuisance, even though it hasn't quite become a nuisance yet. But it is as it were a nuisance in progress. That's how I would treat this case.
Okay, thank you.
Thank you for your presentation and the paper. I really enjoy reading it, and actually I'm not sure about my comment, but I will try because I was thinking we're talking. But I'm interested in the idea of expanding and the relationship between expanding and rights. Because we could think of expanding and acting on our own rights, but also you can think of expanding as acting as representative of the public interest, while the representative of others' rights. And so when we think, for example, of prosecutors, this is basically what they do, no? They act as representative of the public interest to which the victim is part of. And so I wonder if there is, well, of course, there is a distinction there in standing and also in the relationship of the rights, if it also doesn't depend on the kind of rights, because you think of individual rights, but also a category of distinction that is very common in the context of consumer law, collective rights or diffusive rights. No? We have this. Maybe it's more of the civil law understanding of the standing, but there is this idea of collective rights that is built up on a different concept of right. And so I wonder how you see this relationship, because it seems to assume in these American cases that the public authorities, you're not sure whether they act as representative of the public interest, whether there is a right there or not. And so I'm wondering whether there is a need of more refinement on these two elements, standing on one hand and which kind of rights, and whether it's something worth thinking or not.
Thank you so much. So it's definitely worth thinking more about. Let me just do a little bit of thinking out loud about it here and now, and then think more about it in, as it were, a cooler hour. Here's the way that I, in general, think about standing in private law. So there's a totally fabulous book that came out last year about it by Tim Liao called Standing in Private Law, and it just it's totally amazing. So Tim's reading, which I think is right, is that normally standing follows the right. And then there is a non-trivial class of cases in which standing does not follow the right. And so third-party beneficiaries in contract are a clear case, but he also has an extended discussion of this unjust enrichment case in which the will was void, but it had already been paid out, and the heirs so if the will was void, there was therefore an action to be made in unjust enrichment by the estate. But of course, the executor had no interest in doing that. Why? Because the heirs were horrific people, and the testator had left all of his money to worthwhile charities. And so the executor had no interest in bringing an unjust enrichment action. But question, can the family members under the statutes of descent bring an action? And the answer is yes, they can. Why? Because there is a right, and this is the person who is in a position to actually enforce that kind of right. So now, let's take that to the case of public nuisance. The key for analyzing it, it seems to me, is whether in these kinds of cases, we can understand the standing without first understanding the right. I think the thing that's so great about Tim's analysis is he said, no, it's a rights first picture, and then there are rules of standing that will sometimes allow someone other than the right holders. Now, particular case of public nuisance. In 19th century England, a public nuisance action could normally only be brought by the Attorney General under a relator action. And most of the cases, it turns out, were brought by, so the Attorney General basically just needed to sign off on it. And the cases, there are lots of cases involving bleach factories, and sewage from Birmingham was one of the leading cases. So it turns out that you had these wealthy people whose country houses were downstream, who were the members of the same political party as the Attorney General, and so the Attorney General would allow these to be brought. But the standing the Attorney General had, although it was exercised in a way that we might, looking back on it a couple centuries later, find kind of questionable. Nonetheless, the standing was predicated on the right that the landowner had, not on the Attorney General somehow acting for the public. Now, I mention this both because it engages with what you asked, but also to draw attention to the way in which this, although they were brought by the Attorney General, they were the exact opposite of the eponymous picture of the plaintiff as a kind of private Attorney General. Instead, it was the Attorney General enforcing what is fundamentally a private right. Now to your question about, are these individual rights or collective rights? The answer is, in some sense, they're both, because they are rights that people have as members of the public. However, the question of public nuisance, plainly a public authority is entitled to require that a public nuisance be abated. Public authorities sometimes move slowly, sometimes do things of their own. There's some 19th century England cases of public nuisances that were also crimes that were brought as public nuisance actions because the criminal prosecution would take so much longer. And so that, right, in the 18th century, criminal prosecutions took a couple of minutes. Henry Fielding, as a judge, would decide 25 cases a day or something, but criminal cases a day. But in the 19th century, criminal process was slow, this was faster. So too, think about the climate change case. Is litigation a good way to solve the climate crisis? Well, maybe it is, maybe it isn't. That is, putting pressure on these large polluters, the largest polluter, the largest defendant in the Fonterra case. One of their arguments was, we're insignificant. We only produce 0.25% of the greenhouse gases in the world. One company is producing 1/400th of the greenhouse gases. No wonder there's a problem. But anyway, the point is, New Zealand kind of leads the world in environmental legislation. It's moving slowly. But the reason that Michael Smith can make a claim is that he has suffered a wrong. Now, is he partly funded by Greenpeace, would like to see more regulation? Is there a hope that this case will provoke more regulation? Yes to both things. But the success of the claim depends on the violation of a private right. And the fact that the private right has this collective element to it makes it more interesting in a certain way, but doesn't make it cease to be a private right and doesn't make it cease to be a wrong, personally.
Thank you for your presentation. I just have a very simple question. Not familiar with court law. If I understood you correctly, you wouldn't have a standing in public nuisance if you just have suffered a pure economic loss. Is that right? You need to suffer something more than a pure economic loss.
You need to suffer an interference with your use of the thing that is public.
Okay, but if you suffer a pure economic loss, you just don't have standing.
Well, it depends what you mean by it being a pure economic loss. And so if you suffer an economic loss that is consequential on your inability to, say, use the public right of way, then you have standing. But if you suffer a pure economic loss because someone else is unable to use the public right of way, you don't. So suppose I block the public right of way, as a result of which Alex is unable to deliver raw materials to your factory. And your factory, therefore, can't operate during this time. You have suffered then pure economic loss. I have not committed a wrong against you. The only way you can protect yourself against this is by having terms of your contract with Alex so that Alex can then suffer a consequential loss. But it is the same as if I Alex, I apologize for making you the plaintiff here because of all of this trouble. But if I negligently, I'm not going to injure you, I'm just going to damage your car. If I damage Alex's, or I guess it's raw materials, so it better be his truck. I damage Alex's delivery truck, he can't deliver the materials to you. You have no claim in negligence against me. Why? Because I violated Alex's right, not yours. So too, if I block the road, Alex can't deliver the materials to you. I've wronged Alex, but I haven't wronged you.
Okay, so related to this one? No, mine is just if there's time left over at the end. Okay. Are there time to go forever?
Yeah, you gotta watch out for these.
I have the same doubt, but I don't know much about your post. Common law agreement is not, but what I was thinking when I listened to your expression was that maybe interference with use depends a little too much on the description you make about how I'm using things. In the example you just made, you can say that a merchant on the island is using or availing himself of the breach. Because since we have a breach, I can receive my customers. You broke the bridge, now you're not allowing me to avail myself from of the bridge to conduct my business. This is one way to make problematic the distinction between, well, interfering with use or the use of others. On the other hand, I might not be using the bridge to transport my goods because my customers are coming to me. But if they cannot come, I will to deliver. So what is it? What difference does it make whether I'm using it, actually using it, or whether my potential use is my second best? It's my second alternative. My second is always latent plan there. If my customers cannot come, I can deliver. When you break the bridge, you impair both my options. I cannot receive customers, nor I can. So in this way, you convert pure economic loss into consequential damages very easily by describing the situation. And this is, I think, problematic. The first part I love it, how public roads with the Kantian view about that's great. But when it comes to interference with use, maybe I need something else.
Okay, thank you so much, Diego. So I have a general comment and a specific comment. The general comment is that the law of torts is always sensitive to descriptions. And indeed, that is why so much litigation is the opposing parties trying to redescribe the facts to bring them within the scope of the doctrine that is going to be favorable to them. So in your case, if I was using the road, then, sorry, you were using the road, I blocked the road, you're no longer able to use the road. You were not using the road to bring customers. That is not a way of using the road. That is a way of relying on the actions of others. Your customers are not your supplies, they are human beings. You are not transporting them yourself. And so it seems to be easy in that case to say that I have not interfered with your use. And then we say, but I had plan B. My plan B was, as it were, to take the product to the customers instead of bringing the customers to the product. Which is to say, you're saying, well, you've interfered with it. Well, I wasn't doing it, but I would have done it. Why would you? Well, I would have done it because you did this thing which wasn't an interference with my right, and so I would have coped with it. Why? But notice that in that case, I'm not interfering with your ongoing use. I'm interfering with your possible use. You weren't using it. I didn't require you to redirect. All I did was fail to provide you with the conditions in which you could have redirected had you needed to redirect, which you didn't need to do if I hadn't done the thing. And so you can't, as it were, bootstrap and say, well, my plan B therefore becomes my plan A, because your plan B is not a plan that you could possibly have had, because it is conditional on a condition that was not met. And so you say, I'm going to deal with this problem in the following way. It's like the joke about the people trapped on a desert island and they find a can of food. The economist says, well, we'll assume a can of it. You can't assume that it's available and then say, well, assuming it's available, because that isn't the right description. And so that's why you can't, it's sensitive to the description, but you can't just, as it were, help yourself to the most favorable description of what you would have done, because you wouldn't have done it if I hadn't blocked the road. But you can't say, well, if you had blocked the road and the road was still available, this is what I.
I was not saying exactly that. I mean, suppose Pavilion. People, and I,
No.
I'm not assuming that the situation in which the bridge is not blocked, that's a precondition, I understand.
Yeah.
But I'm not saying, I'm saying, in general, I'm willing to receive my customers. And in general, if they don't come, I'm willing to deliver. And they cannot move, but maybe I can get a special service, as it would be this case in Spain, they could transport fruit and food to supermarkets, so I can move now. But now they destroy the bridge, what difference that makes in substantive terms? I'm using the bridge for my business, or availing myself.
Okay, but well, so if you're doing it for both, then you can recover for the part that was your use of the bridge, but not for the part that was your customer's use. And so the fact that your use of the bridge was interfered with. Yes, of course. The fact that there was something else that also happened, that's just pure economic loss. And so there will then be a question, well, how much would you have used the bridge? But there, as in any kind of inquiry of that kind, you have to ask what the baseline is. And the baseline would have to be there being no public nuisance, by not having blocked the bridge. And so the part of your economic loss that is consequential on your being unable to use the bridge, of course you can recover, but not the other.
Well, thank you, discount. I think that the idea of use is very broad. I'm using my stuff even when I'm touching wire. Using my cell phone now, in a sense, determining which way.
Yeah.
Yeah,
but your other, your old phone that's sitting in a drawer in Barcelona, you're not using it now. But also
not for you to judge.
but the other thing is, that's because it's your property. But now, the
It's my
road
right
that
to circulate.
the road that you take to get from Girona to Barcelona, on which we had such a lovely drive a few years ago, you're not using it. Maybe you're using your cell phone now. Maybe you're using it as a paperweight in case it suddenly gets windier. But you're not using that road. Your property is something with respect to which you can be wronged even when you're not using it, because you have both possession and use of it. You do not have possession of the public road. You only have the use of it. Not only that, you only have the use of it for the specific purpose for which it's there.
I think we could go all day, but I'll try not to. On the Exxon Valdez, I agree completely with you that it's unhappy in what turns out would love to solve that. But I think following up on Diego's point that you're giving a description that doesn't really respond to the position the court has. Here's how. It's perfectly true that the native tribe had its right to use interfered with. But the essence of the pure economic loss rule is to say you need more than an actual interference. So suppose that Greg, who doesn't know how to fish, but could learn how to fish and could fly up to Alaska and could fish, but can't because of the Exxon Valdez oil spill. He doesn't have interference. But people who live around the bay and would normally recreationally fish there or for subsistence fish do. And that's interference with their actual rights. They're like the people who are in the vicinity of One Meridian Plaza and have to detour every day, twice a day, and it takes extra time. And that's just not enough. You have a rights violation at that point, but you don't have enough for the private cause of action. You have to have the pure economic loss. It's the pure economic loss is not a consequence on the for having recognized an action interference with your right. It is the interference that triggers the right. Not consequential damages, but so maybe we're stuck at a description problem, but I think American courts would not describe, would would reject your description of the Exxon Valdez, and that doesn't really fit the way the Exxon Valdez puts it. But the second one that opens us to different terrain slightly is transaction, a very strong word to describe both private nuisance and public nuisance, because the most distinctive thing about them in some ways is their conditions. That is, the most interesting nuisances, it's probably possible to have nuisances that are very difficult to distinguish from negligence, where somebody interferes with the use of property, but it's just kind of short-lived and one-off interference. We tend to absorb all that into ordinary negligence doctrine, but we treat nuisance doctrine as an ongoing interference condition. That's true in Exxon Valdez, it's true in Meridian, it's true in the really big cases involving opioids and lead paint and tobacco. And so it seems odd to describe enduring conditions which invite the most characteristic remedy for nuisance, which is vapor. That's the most characteristic remedy that nuisance attracts. And you know, it's not available as a in connection with negligence. As negligence, the characteristic incident is a one-off accident that you can't enjoin. It seems very aggressive to describe that as transactional in the way that you might describe a one-off risk imposition resulting in harm in negligence, this transaction.
So always like to have my view described as aggressive. So let me forgive me for being defensive, but here's why it is transactional. I go back to the little skit I do for my torts students. Plaintiff says that defendant is not allowed to do that to me. Do what? I can't sit in my backyard. Or the Boomer case, I can't breathe in my house. This is a case where there's about 1 millimeter of dust a day, and that makes it through cracks in the windows because it's such fine dust. What have you done? What the defendant is not allowed to do in the private nuisance case is interfere with the plaintiff's use and enjoyment of the plaintiff's land. That is a transaction. It is what the defendant did to the plaintiff. What? Interfered with. So too, in the public nuisance case. A public nuisance can be ongoing or it can be short-lived. The early cases involved blocked canals, ditches in roads, and so on. And those sometimes were there for a long time and sometimes were there for a short time. Because again, it is a nuisance to block a private right-of-way. If I have an easement to cross your land to get to the beach and you put up a gate that is and block it, that is my only action against you is in nuisance. Now, because of that, it's a violation of a right-of-way, same thing in the public case, and same transaction. And again, the reason that in a private nuisance, ordinarily, it will be ongoing. Nuisance is a tort against the land. It is the relation between one landowner and another landowner. And it is normally going to happen when it is ongoing. But although some of them can be treated as negligence, blocking the private right-of-way, there's no negligence action. It is entirely a new private nuisance action. Now, coming to the Exxon Valdez, the requirement that there be economic loss looks to me like it is one of two things. The first possibility is that it is just a doctrinal confusion saying, oh, we want to protect certain kinds of economic losses. We don't have a systematic reason. And so in some of the fishing cases, you get judges saying, oh, well, fishermen have always been favorites of the law. No analysis, just that kind of thing. Oh, well, let's make this person a favorite too. And again, you can imagine, though not saying that in the Exxon Valdez case, oh, well, fishermen have always been favorites of the law. Native Americans have never been favorites of the law, so therefore. And that's probably what they were thinking. But Here's the other way of thinking about it that is perhaps more charitable towards their analysis. That would say they're treating economic loss as a proxy for something being more than de minimis. The fact that you can't go spend your afternoon fishing there, yeah, get over it. So too, the fact that if there is a public nuisance as a result of which you need to take your stuff off the barge, get another barge, load it into horse and carriage, carry it around the obstruction, put it in the new barge, that's major. On the other hand, the fact that you have to take a slightly different route that is 30 meters further, that's de minimis. But that is poorly captured by saying that one is economic loss and the other is not. And it seems to me that on either, or these are just our prejudices view, that's the wrong way to do it. Or alternative, this is just a proxy for it being more than de minimis. And so it seems to me that there are lots of de minimis cases of public nuisance where a legal order requires that there be a lawful way for members of the public to get from any location to any other location. Almost every urban area is going to be redundant with respect to that requirement because there are going to be lots and lots of different routes available. And so if you merely need to take a small detour, that's going to be de minimis. But it seems to me that focusing on the economic case doesn't actually cover it at all. It seems to me that that is giving up. And again, this is why when I talk about the American cases, I talk about Bernie's article, Can Law Survive Legal Education? Because if you try and do things in a purely functionalist way, then it turns out something will count as a public nuisance. I mean, this was kind of Prosser's view. If you can just put whatever, it's just a residual category. And my view is, no, it's not a residual category. It actually has its own doctrinal structure. And whereas if you say its doctrinal structure is you can recover for pure economic loss without the violation of a right, then that's not a doctrinal structure. That's just saying these are just the prejudices of the court, because they say in general you can recover for pure economic loss, but in this case you can. Why in this case? Because there's pure economic loss. That's not.
No, here's the thing, the third view, I agree with you on the prejudice view. And one worries that the prejudice view is actually the view that, given that the American treatment of Native Americans was genocidal, there's some reason to worry that they're not favorites of the law, just doesn't get to describe it. But the doctrine position is a third position. And the doctrine position is this, it is that you need more than a rights violation, which would be sufficient for establishing a public nuisance. But for the private cause of action, you need a rights violation plus a harm. And the harm that will do is pure economic loss. You don't need to show physical harm in the form of damage to property you own. So if you put the fisher in that category, they don't have to establish that they own the fish, which would be an impossibility. All they have to establish is that they've suffered pure economic loss, but they already have. We're assuming that you already have established by the existence of public nuisance the violation of a right you have, which happens to be a public. But you've got the rights violation.
Okay, but if you've got the rights violation, then you have to show that it's not de minimis. Then it just goes back to using economic loss as a proxy for it being de minimis. Again, think about the case in which the road is blocked, as a result of which I am unable to get to my land, but I wasn't using it for any economic purpose. or I need to take this major detour. And it turns out that I can't show a financial loss because I was just out cycling. And you can say in response, oh, well, look how it improved your fitness. You got a longer ride in. But it took me an extra day. Yeah, but you weren't gonna make any money anyway. That doesn't seem like the right way of putting it. And so the idea that the loss needs, that there needs to be loss, yes, that the loss needs to be financial, that can't be more than a proxy.
It's the minimum. It's a fine. But it also sets out why Kathy, you and I don't like Kathy's position. But you just gave the reasons why Kathy's position is quite a plausible position, which is that you clearly interpreted it just the way you said it. So I think you'd be better off interpreting as you could interpret the pure law school license. Oh, this is a commercial court. You get recovery when you had a financial loss, but if you're just on a recreationally cycling, a recreational fishing, a recreation, anything else, forget about it.
Yeah, but it's not, again, doctrinally, again, there are these, as I keep saying, the American cases have gone off, as it were, on a detour, maybe a frolic of their own. But the idea that doctrinally, if you look at the development of the doctrine, that's not what it's about. That all of the 19th century cases are cases, some involve economic loss and some involve gentry who wanted to be able to water cattle from the river. Why do they keep cattle? Well, because a good country squire has cattle on his land. And owning the cattle was in fact a net economic loss to this was conspicuous consumption. You would have a bunch of peasants who would care for your cattle. Why? Because I'm a country squire. That would be blocked by the economic thing. To say, I mean, Kathy calls it a modern business tort. But again, it is a consequence of her view that the same rule should apply for negligence as for public nuisance. Why? Because the only way you can explain these cases that she likes is by making it merely about efficient allocation of resources. And that's not what the traditional law says.
So this is the point at which we agree, because we disagree on it. Yeah, we both agree on it. But the point that you're aligning is that the economic loss rule is a threshold rule that defines a minimum interference that will count as sufficient interference.
Wait, you can't call it a pure economic loss rule. You mean the consequential loss?
No.
It's not pure economic loss if you have said that you're going to agree with me that there has to be a rights violation.
I'm not, of course, agree with you. I'm just giving,
No, but
giving you the description of the American
if courts agree with me that there's a right violation, they can't also insist that the economic loss is pure.
Sure they can. They can say that because what the pure economic loss rule means is there isn't physical harm. You don't have.
Yes, but again, that's physical harm is not a relevant thing. Rights are the relevant thing. Physical harm matters because you have, in the tort of negligence, a right to the integrity of your body and property. It's not that we say, oh, we have one rule about physical harm and we have one rule about economic loss. We have one rule about rights. That is my claim. And if you say that this is an exception to the economic loss rule, because the economic loss rule is about physical harm, then defamation is an exception to the economic loss rule. Liability and trespass to land is an exception to the economic loss rule. That's not the real rule.
Oh, okay, but that's a far normative position.
No, but
It's just not an understanding of it's just a misunderstanding of what American courts are saying.
yes, and again, that's why I said I can't explain what American courts are doing. It's like when I discuss defamation, I say I can't explain what American courts are doing with defamation because they've abolished the tort of defamation.
But here's the thing, it's not hard to explain what American courts are doing, okay? It is just that they're not doing what your normative theory calls for them to do. It's easy to explain it. To explain it is to say that you normally recover in negligence for pure economic loss, and that's for physical harm, and you don't normally recover pure economic loss, though there are many exceptions. Okay, and then it looks at public nuisance. It doesn't see in public nuisance a freestanding separate tort of the kind misrepresentation or defamation are. And it says, well, the way that the pure economic loss rule functions in public nuisance is the way that it functions in negligence, which has it's a scope of responsibility rule that says you can have a right interfered with, but not with a private claim. And in order to have a private claim, you have to have more than interference with a right. You need what counts as a harm. But here, harm does not require physical harm. That's not your normative position, but that is their position.
Please sum up with.
Yeah. Yeah.
We have to take the copy.
Yeah, okay. So, yeah,
Thank you very much, Arthur. My short comment is about the nature of use. Perhaps the nature of use depends on the nature of property. It seems to me that the dual nature of property communicates to the nature of a nuisance. Therefore, in both cases, the law of a nuisance is private and public. Its nature is dual, like a property. Thank you very much.
so I think I'm not sure I fully follow what you're saying, but property plainly has a public dimension to it. But there can be an interference with property that is exclusively private. That is, when I make a loud noise that regularly keeps you up at night, that is an interference with your property. And it's purely private in the sense that it is just between the two of us, between the two of us as neighboring owners or occupiers of land. By contrast, it seems to me that there is an inescapably public dimension with respect to public nuisance, because there is no private matter. It is rather, there is a private matter within the context of the public rights. And so the public aspect of property is that it exists within the structure of a legal order in a way in which the public structure of public nuisance is public in a further respect.
Thank you, Professor.
Yeah.
Well, let's resume the academic journey with the last lecture of the second workshop. This lecture is entitled The Unequal Side of Law Under Distributive Justice's Watch and is given by Professor Diego Papayanis. Professor Papayanis is a lawyer and has a master's degree in law and economics from the University of Buenos Aires and a PhD from the Pompeu Fabra University. He was later a visiting research scholar at Yale Law School. He is currently Serra Hunter Professor, Philosophy of Law, and researcher at the Cátedra de Cultura Jurídica at the University of Lyon. His lines of research focus mainly on the philosophical foundations of private law, causality, the economic analysis of law, and the general theory of law. He is currently developing a new line of research focused on the contribution of private law to the equality of life. Professor Papayanis, thank you very much for your presence.
Thank you very much for the presentation. Good morning. Okay. First of all, I want to thank the University Externado de Colombia for hosting this second workshop of the network. And especially, I want to thank Alexander Vargas for all the work he put into the organization of this workshop. I know that he had to overcome several difficulties. It was not easy. So thank you, Alex. In this paper, the question I want to address is whether an equal federal law can be justified or defended within a more general framework of distributive justice. According to what I would call the orthodox view of private law, it can. In fact, distributive justice considerations are to be excluded from the design of private law, and especially in legal adjudication. They have no place in legal adjudication. This is because the law, private law addresses in general interpersonal problems. It is like an expression of the principle of corrective justice or interpersonal justice, and in contrast, distributive justice addresses collective problems. And it is impossible to solve collective justice, general distributive justice, within the limited framework of private law, which has a bilateral structure that is limited to the parties of the interaction. So the question, the why me question will always be on the table. Like, why do I have to contribute just because I was unlucky enough to be in this particular interaction with someone older than me? And on the other hand, the why not me question is also relevant. Why me? I should deserve some redistribution, but I was not lucky, for example, enough to get hit by a car owned by a rich man. So these are the limitations of the bilateral structure of private law, that in turn means that the burdens of distributive justice should be held by the whole society and not particular plaintiffs. This is of course, this does not mean that for the supporters of orthodox private law, distributive justice considerations are irrelevant. They think that they're relevant, but that should be handled through public law mechanisms, taxation, public spending, welfare programs, redistributive programs in general. The starting point of of orthodox private law is the claim that in the state of nature, we all have a right, an innate right to freedom. Since everyone has this innate right to freedom, then the freedom of everyone has to coexist with the freedom of everyone else. And this means that no one can be constrained by the mere will of others, or the mere desires or the needs of others. This is the idea of normative independence that it is implied by the idea that persons are to be conceived as self-determining agents, that is, agents that decide by themselves what goals they want to pursue in their own lives. Now, how can we respect the the other person's right to freedom in the state of nature. And this is something that always called my attention, that the idea is that the manifestation of freedom, the immediate manifestation of freedom is the right to my own body, because I cannot act not through my own body. And this is translated into some kind of right not to be touched, which is without my consent, which is a very limited right. So as long as I don't touch you with your consent, I do not violate any of your rights, and this is the only right that we all have in the state of nature. As you can see, this state of nature depicts a rather precarious world in which only very simple plans can be undertaken, can take place. For example, Weinberg gives this example: if someone takes an apple from the tree, I cannot grab it from your hand, because if I take it by force from your hand, I will have to move your fingers against your will. So I will violate your right or your physical integrity. But if you leave the apple on the table even for a second, I can take it without violating rights, because I'm not touching you. This conception of the inner right to freedom grants reciprocity. It's true, but I think does not grant significant freedom. And Kantians might think the same, because for them the most rational step is to move towards what Kant calls the civil condition, which is civil society with a legal system including more rights. In the civil condition, new rights such as property rights or the right to contractual performance are introduced, are recognized. And this is like a fantastic technology, because now we can exercise control over external objects, things, without being in physical contact with them. Now, if I own the apple, no one can touch it without my consent, even if it's on that table. And at the same time, since we now have contractual law, contract law, now we can engage with others in more complex and sophisticated plans. This new system of rights should also be directed to securing reciprocal freedom. So whatever the configuration of the new property rights, contractual rights, contract rights, they should respect this idea of reciprocal freedom. Now, the problem with these rights, especially property rights, is that they create the possibility of unlimited accumulation, and therefore they allow the possibility of subordination. That is, for those who are left with nothing to acquire, once everything has been acquired for someone else, the person who didn't acquire, for example, a piece of land, would need the permission of someone else to occupy the space that he's occupying. And this seems to violate clearly the principle of independence, because I will be dependent of another person's goodwill. So the prospect of systematic dependence calls for institutions of distributive justice. And ultimately, the legitimacy of private rights depend on the fact that independence be restored. And this is done through mechanisms of distributive justice. So distributive justice mechanisms are justified or entering the scene to legitimize a system of private rights, such as property rights. This is in a very briefly explain the core, I think, of this Kantian view that is translating what I call, or is present in what I call orthodox private law. I have three lines of objections of criticism. The first is that the description of the status of nature is implausible. Second, I will argue that institutions of distributive justice alone by themselves cannot guarantee some genuine or true independence. And third, I will explain that orthodox private law assumes a rather limited or narrow view about the domain of distributive justice, and also that it misses to grasp the problematics of poverty in real life. I'll begin with the state of nature. In the state of nature, people are conceived as independent, and this implies that they are inviolable. They cannot be constrained by the right. They only can be constrained by the rights of others, as I said before, not the will, the needs, or the desires of others. So since the only right that there is the right not to be touched without consent, Achilles, for example, could take all the apples in the tree, leading Hector to starvation and ultimately to death without violating Hector's rights. But is this description plausible? This is what I want to argue that is not. Because one thing is to claim that the state of nature is a pre-institutional state of affairs. There are no institution, no legal rights. Another thing is to claim that it's a space free of morality. The supporters of the Orthodox parallel do not think this later thing, because they claim that there is at least one innate right, which is a moral right to freedom and right not to be touched. But the question is, why is that the only right that exists in the state of nature? And I think that it's plausible to argue in the following way. Suppose this is the argument I want to make. The fact that Hector will die if Achilles takes all the apples in the tree, combined with the fact that Achilles cannot eat all the apples before they rot, it's a reason for Achilles not to take all the apples in the tree, not to appropriate of everything that is to eat in that situation. Absent other countervailing considerations, this is an undefeated reason. So Achilles would be bound to act on those reasons because there is no other opposing reason to do anything different. So he should abstain of taking all the apples. So if this is correct, then Achilles would be doing something wrong if he takes all the apples in the tree, even if he cannot eat them, just to see Hector die or just for fun. And if it is wrong, it's certainly wrong because of the dire consequences this has on Hector. What else? Now, from there, it seems reasonable to claim that Hector has a right that Nagon determines his death. In the state of nature, Hector has a right that Nagon determines his death for not good reason, just for fun. I think this is a plausible line of argument, and this is consistent with something that I think is also clear, that respectful coexistence requires much more than not touching others without their consent. I would think that Achilles is disrespectful to Hector if he takes all the apples in the tree, even with no benefit for himself, just to be mean to Hector. Now we can push the argument a little further. We accept the previous reasoning and ask whether it is possible to claim that in the state of nature there is a moral right to unlimited appropriation of scarce resources. Scarce resources, not scary, scarce resources. And I think this is hardly the case also in the Kantian vein, because this is not a conduct that can be generalized. Can be converted into a universal maxim, appropriate of everything without leaving anything to the other, leaving everyone else with nothing to acquire. Well, this is not a liberty that everyone can exercise. So if this is correct, then also in the civil condition, rights can be limited when the noble operation is expected to cause antisocial effects. This is the way in which I question the description of the state of nature, and then in the civil condition, I question that property rights should disregard the distributive justice consideration. The second line of objection is that, as I said, that distributive justice alone cannot guarantee true independence. If you remember, reciprocal freedom is inconsistent with interpersonal dependence. So no person should depend on the will of others as a consequence of normative system that allows for unlimited accumulation. And public law redistribution is supposed to solve this problem. However, as Hanno Dagan has argued, once institutions of distributed justice are implemented, this interpersonal dependence does not evaporate, does not disappear. It's turned into a social dependence because the person in need now depends on the state bureaucracy, Dagan says. Weinreb explicitly rejects his arguments. He replies to this in his latest book, and the argument is that the state is under an obligation to provide some aid to the poor, which is correlative to a right to receive that assistance when you're poor. And hence, if you have a right against the state, against all of us, then you do not depend on the goodwill of the government or the state or the collective. You have a right. But I think the argument is insufficient because the duty to support the poor is undetermined. It has to be determined. And in which way is determined? It's determined as part of a public policy. The decisions about how much redistribution should there be is decided in the public arena. And this calls the person in either a safe stand or the person calls it to some collective decisions, the result of collective decisions in at least two respects. There are ideological disagreements about how much redistribution should there be. So the person is subject to, in a way, to the whims of politics. And this is something that we can check. Redistributive policies change from government to government. They are unstable. And also, sometimes they are not optimal. They are the result of a compromise between different political forces. So there is a dependency on the collective choice that matter. Whether you will receive an amount of redistribution that is enough for a decent life depends on what happens in the best of the worst in democratic countries. Second, there is a contextual dependency, because the availability of resources define whether you are going to get or not the aid you need. So in sum, it is possible that for ideological or contextual reasons, democratic societies decide to grant insufficient aid, say only the minimal for biological survival. But biological survival is not the same as a decent life that is worth living. So this outcome will be legitimate from the democratic point of view, but I think it would be unacceptable as part of the social contract, because it wouldn't be rational to accept a scheme that allows for interpersonal exploitation or social exclusion, and at the same time does not preclude the possibility of factual dependence on the goodwill of others. A different problem that, in my view, is also very important and significant is that public assistance is as the only systematic response to failures of distributed justice undermines the social basis of self-respect. That, in the Rawlsian theory, is one of the primary goods. And the reason I say that is I rely on some empirical studies and then in common sense. But I found some literature that some empirical studies conducted in the United States about poverty. And think, okay, that's so obvious. Yes, because a minimum exercise of empathy will tell you the same that I'm going to explain here, that is that recipients of welfare programs usually suffer from anxiety and shame. They feel like that they have failed in this, what I have called this acquisitive cumulative competition. This is part of our capitalist countries, but is direct consequence of this Kantian view about how the rights should be distributed. This is also the fact that you're a failure. If you need the assistance of the public, it's also perceived, and the people in need know that socially are deemed to be failures. So even if receiving social welfare is a right against the state, as Weinreb says, it is curious that it's a right that now one exercises with pride. Instead, they exercise it in the most concealed way. And here, the example of the food stamps, some tickets to get food, there are some programs in the States, in the United States, is very interesting because people spend those food stamps in another neighborhood. They don't want to be seen buying groceries and being dependent on social welfare. Related to this is the fact that people on welfare suffer severe stigmatization and also interpersonal mistreatment. Most of the interview people reported that they have been mistreated by employees when they show the food stamps. They have been treated different than regular customers. And also other customers mistreated them. They judge, for example, the kind of product they decide to buy. It looks like socially it's completely inadequate if you are on social welfare to buy wine, a bottle of wine. Even if it's to celebrate a special occasion in your family, you're not allowed because you are in social welfare. Additionally, people on welfare feel dependent, has this feeling of dependence in at least three senses. The first is the obvious. They cannot help thinking that they are living at the expense of other people. The second is the bureaucratic dependence. They have to do, because aids are conditional, so they have to do whatever the administration says they have to do at the time that the administration says they have to do it. So they feel that their autonomy is being limited, but the system that provides the only help that they can get is this kind of system that allows for unlimited accumulation. And third, some of them feel trapped by the welfare system. They don't see a future in which they are completely independent. They don't rely and they get a job, they get a normal life. So it's for depressing to be on welfare. It's not like, okay, let's allow private law to do whatever it does, and then we solve it through public law distributive mechanisms. It's not that easy. And finally, 90% of the interviewed people thought that most welfare recipients were responsible for their own situation. 90% thought that their fellow recipients were lazy or they made bad choices. But when they were asked about their own situation, they said, no, my case is different because my father died when I was young, I had an accident. They always find some excuse, and I mean excuse in the sense of some reasons that make understandable why we are depending on social welfare. But this is beside the point. The important point is that social stigmatization is so powerful that even affects the people that is being stigmatized in the sense that they share the stereotypes associated with being a recipient of social welfare. Of course, you might think that all this is contingent and that public programs, redistributive programs can be improved to be, for example, more discreet to avoid social stigmatization, and it is true. These are all contingent facts, but they are invariably present in all societies I know. And second, and most important, is that the roles assigned to public and private law, this institutional distribution of labor, is highly divisive because it tells us that there are active members of society that can support themselves, that can contribute to the common pool, that add value to society. And on the other hand, the other people that are passive members of society that cannot support themselves and that only take from the common good. And this is something that I think cannot be solved within the welfare program, public law, redistribution programs. Because if you are on welfare, it's a conceptual matter that you take more than you give to society. In a sense, the social contract is not rationally acceptable thing under these conditions, because in the Rawlsian original position, people will do everything to avoid the social circumstances in which the social basis of self-respect are undermined. So they wouldn't accept just private law to wreak havoc because we have public law distributive justice institution that will solve the problem afterwards. On the other hand, redistributive private law, I think it's much better because it does not generate any of these problems. Redistribution in private law is silent, completely discreet, and is mostly preventive of exploitation and social exclusion. Private law redistribution is not attached to any shame or consequently any anxiety. So the redistributive effects of private law should be taken into account when you design public policy. This is the main thesis I wanted. The last criticism is that the scope of distributive justice as conceived by orthodox private law is too narrow. Remember that redistribution is necessary to legitimize a system of rights that can create and usually creates social exclusion and hence subordination. Arthur Ripstein, in his book on Kantian theory, Force and Freedom, has very good examples. Like two, if illness and medical expenses usually lead citizens to poverty, the state can create a universal health system. And the second example is that if the labor conditions are really dangerous and unhealthy, and some people get terribly injured, well, the state can regulate labor relations to prevent those detrimental effects. I think these are very good examples of distributive justice policy, but I don't think they fit quite well within the Kantian framework. I'm sorry. But what is the problem? With the labor law example, the question is why restrict the autonomy of persons? Why not let them bargain? If you don't want to accept this job, don't take it. No one is forcing you to take it. And you cannot force me to give you a job in different conditions. And then we have distributive justice institutions. If you break your back working for me, don't worry. We will give you some food stamps. That would be, I think, the consequences of the Kantian framework. Of course, say no. But the first example is even worse, I think, because if someone is in a poverty condition because of illness, suppose a child that is born blind, that unfortunate situation is not the consequence of the system of rights that it's just unlucky. So how come you impose taxes on other people who did not benefit from that fact that the child was born, to support the child? I think that within the Kantian framework, it's difficult to explain that. And this narrowness, in a sense, is normatively plausible, I think, and also does not fit the practice in our liberal societies, because in our liberal societies, we provide aid, compensation, for example, for victims in terrorism. This is the case of Colombia, also in Spain. And how are victims of terrorism related to the system of property rights? They are not harmed by a system that generates exclusion. So it's not the society's concern what happens to people that are. Actually, it's a fact of corrective justice. There is someone else who is responsible for that. How come distributive justice is pertinent? But I think we all share that is pertinent, that is within the domain of distributive justice. And the same with many other cases. If a hurricane destroys a city, we have distributive justice duty to provide some aid. But that's completely unrelated to the system of property rights that elicits institution of distributive justice. The possibility of subordination created by the system of property rights is the only certification for distributive justice. So all these other cases that I think we will share that are part of distributive justice should not be part of distributive justice according to the Kantian framework. Let me conclude by saying something about why private law is so important in fighting poverty and social exclusion. The division of institutional work between private law and public law entails that public law is there to repair the harm caused by private law. Why let private law to create social harm if you can prevent it with a more fair contract law, a more fair tort law. But even disregarding this question, the problem is that in real life, because this is what we're talking about, we're not talking about conceptual framework, we're talking about what kind of private law we should have in our societies. And in real life, these reparative public policies are completely contingent. They might never be implemented. And as I already mentioned, they are unstable, they change from government to government. But even when they're implemented, they arrive late, always, because they affect vulnerable people. And vulnerable groups cannot wait. Once you are in social welfare, once your son is forced to leave school, whatever aid you can give him would not get him back on track as it was before private law excluded. So it's much better to have private law that does not generate as much exclusion and subordination. Also, the efficacy of redistributive policies depends on the alignment of the different branches of public and private law with the distributive goals. It is naive to think that the public policy can succeed without considering how is private law. Suppose you give Achilles, you give him a subsidy because of his poverty. Then Achilles goes to the market to buy goods and services. And since private law allows the imposition of any terms, then most of the subsidy ends up at the hands of the wealthy people who impose unfair terms or contractual terms. There's no way that public law can make the job alone. It has to be, in a way, has to work side by side with private law. So the argument that I'm defending is not that private law can undertake all the primitive tasks in a liberal society. It's not that private law is better than public law. The argument is very, in a sense, modest. It's not very ambitious because it says, look, private law is not irrelevant. We cannot get rid of private law saying, no, these are extremely just considerations. They do not belong to the private law policy we're discussing here when we draft the next civil code. You cannot do just because private law has important consequences and can cause irreparable harm that's very difficult to solve through public law distribution. So the most successful policy probably involves institutions or the design of public law policies and private law policies. And this is all I wanted to say about Forrest Gump. This is all I have to say about this. Thank you very much for your attention.
Thank you very much, Professor Papayanis. I think it has been a magnificent closing lecture, which leaves us with serious concerns about the content, scope, and real function of current private law. We will proceed, as in the previous conference, to open the space for debate with the questions that our sisters wish to ask directly to Professor Papayanis.
Thank you for this, Diego. As you might have suspected, as your I have a few minor disagreements with you. Near the end of your talk, you characterized the Kantian view as treating public law as existing to repair the harm caused by private. That is a misconception, but my comments can be understood as an attempt to exist to repair the harm caused by Hanoch Begun's misunderstanding of the Kantian view. Because what you've done following Begun is assimilate the Kantian view of private law to a version of libertarianism, a view with which it shares a few doctrinal similarities, which are in fact shared by pretty much all views of private law, and no conceptual or normative commitments. And so what I obviously, I don't want to go through everything in detail, but the key to the Kantian view is that distributive justice does not exist, and public law does not exist to repair harm caused by private law. Instead, there is a way we can characterize private law in abstraction from the existence of public legal institutions, and we can therefore understand its transactional structure. But once we so understand it, it's not that it causes a problem that we need public law to repair. It is instead that it is conceptually incomplete and requires public law to repair. The respect in which it is conceptually incomplete is that there is no unilateral standpoint in it, as a result of which private law, by being purely bilateral, is therefore ultimately still, as Kant puts it, unilateral, and so inconsistent with everyone's freedom. But the point of the poverty argument, the distributive justice argument, the distribution of offices argument, all of these are incidents of the constitution of an unilateral standpoint. And although it is true that in a state of nature, Kant says there is no problem of poverty, because there's no problem of poverty because if there is scarcity, it's just scarcity. And although you misleadingly say, well, in a state of nature, Achilles could appropriate all of the apples. No, Achilles could not appropriate all of the apples, because appropriation is making something your own. Achilles could pick one apple after another, and as soon as he put it down, Hector could pick it up, and there would be no wrongdoing. And so that is not the problem. The problem is that once there is a right to exclude, there is a question of whether the person who has no access to something can share an unilateral will with others. And the key point is that at each stage in the Kantian analysis, this goes also for my examples of healthcare and labor law, the question to be answered is not what harm caused by private law is this repairing. That's not the question whatsoever. The question instead is, could it be consistent with a system of equal freedom under laws for a public authority to have this kind of power? And that power goes to the power to redistribute. It also goes to the power to remove things from the tort system, because it isn't that the Kantian view says everyone has private rights and then the state must not interfere with private rights. That isn't it at all. It's that private rights must be consistent with the freedom of everyone under law, and therefore a public authority must have certain kinds of powers to do so. And then you have to show that each of these powers is consistent. Those powers are not made consistent if they can only be exercised in a way that is humiliating to those who are the beneficiaries of. And so there is no, oh, well, distributive justice has its problem. Welfare systems in modern liberal democracy do not do a good job because they're fundamentally humiliating. And they are corrosive of the public culture on which they depend. But that thought can be expressed entirely in terms of the idea of creating a system in which people are all participants in the unilateral. Same point with respect to something like labor law. The point is that if there is a systematic inequality of bargaining power, that is a problem for the possibility of sharing an unilateral will. It's not that it is caused by private rights. But I also want to say something about your positive proposal, because the suggestion that somehow we could change private law in a way that it wouldn't be humiliating, or that it would somehow solve all of these problems and make us not need distributive institutions, is actually an idea that sounds like an alternative only because of the way in which is radically underspecified. And if you think through what it requires, it would be far more humiliating as well as being completely unmanageable. Because what it would require instead is every shopkeeper to figure out, how much should I charge for this? Oh, should I have a price for wealthy people or a price for poor people? Oh, well, I could have different ones. Why? Well, because I should be able to do the knock the gun thing. Respond to need when there's need, but I shouldn't need to respond to need. I should be able to just be in it for myself when there isn't need. And so when Diego and I go into the shopkeeper can charge us an arm and a leg, but then there are the other people who need to take care of this condescending way. And so the thing that you complain about in public social institutions, you instead in the gun picture insists on importing into the moral psychology of every human being and every shop. They should always think about the welfare of the person with whom they're dealing and think about the impact of their act on the welfare of the person of which they're dealing. And that is to say, they should be noblesse oblige in the private case. And that is even more corrosive, the social basis of self-respect. So too, the person who thinks, oh, well, I mean, there will be some people, oh, great, I'm opportunistic. I get the discount. I now get a senior's discount. That is kind of totally perverse. I should be the last person in the world to get a senior's discount, but it's not a bad idea to have it just tied to age. Why? Because then it's not connected in that way. And so we prevent this kind of problem. But let's put it in private law. Let's tell the private actor to do this the right way. And so how much you bargain with me? Oh, you should bargain with me based on your assessment of who I am. And this seems to me that I'm going, see, I can say, hey, all of the other seniors, they're old. That's their fault for them. But me, I'm different. I'm just old because of the earth revolving around the sun. So that's not my fault. I'm special. I'm give this. But the point is, if there is a problem about stigma, then moving everything into private law, the problem is you're trying to solve the exact same problem. You're trying to solve the problem of people having unmet needs. And you're trying to solve it not by having an idea of equal citizenship, but instead by an idea of private parties all considering every possible reason. The gun, I hope you don't follow the gun in trying to take all of this from Raz's theory. But the gun says, oh, this is like Raz's theory of reasons, and what you should do is be responsive to the real reasons. And then we have these intermediate things that are responsive to the reasons. But once you put everything into private law, all that you've done is eliminated Raz's theory of law, as well as Kant's theory of law. Because you've eliminated all law, because you basically just said everyone should consider every situation on all of its particulars, be nice to everyone else. And as Kant says, it is impossible to find such a situation. But just to sum up, basic point is the Kantian theory is a theory of why it is that a public authority has certain powers. It is not a theory that says all of those powers are solving problems of the public. All of those powers are solving the public problem of how it is that everyone can be members of a public standard. And that, therefore, can't be tied to sorry for going this way. But just imagine how long.
Thank you, Arthur. Thank you. I expect disagreements, of course. There's a lot to say, but I will focus on some general lines. First, I never construct the orthodox private law supporters are libertarians. I try to be very clear that you are not libertarians because you believe that the state has a place, but I think that it's not the correct place. I mean, it's exclusively linked to public law.
The libertarian concept of private law. You don't have.
you don't have a libertarian conception of private law, only in private law, but libertarian conception only means that whatever there is in the world is brought by someone with his effort, so distributive justice has no place. This is what defines a libertarian.
Yeah, that's it.
No, of course. That's why I agree that you're not libertarians. You're just mistaken, not libertarians, mistaken for different reasons. No, you think that distributive justice is just a matter of public law, disregarding the potential of private law to contribute, and disregarding the dangers of private law trying to be neutral. There's no neutrality here. Private law can play in one team or the other. There's no neutrality. This is the first thing. The second, this is the paper I present. This is a very brief paper for the conference, but it's based on some book chapter that I'm working on that is 50 pages, and I explain all the omnilateral will. I explain everything. So, but I don't see the relevant. It's true. Public law is not just there to solve the problems of private law, but it's the part in which I'm interested in. There is no private law actually without public law in your reconstruction. I understand that completely. Private rights are completely undetermined. You say, okay, I have a right to my body. What does it mean exactly? It has to be determined. It has to be determined through public law, authorities, judgments that have to be always faithful to one way of analyzing the relationship between the parties. And you cannot go beyond that. I understand all that. But the part I was intended to focus on is the part in which distributed justice redistribution enters into play. And why redistribution is justified in that framework? Because private law might have terrible effects, leaving some people in a subordination. In that respect, I don't think I'm mistaken in the reconstruction. Yes, I think I'm not. Second, you say that my description of the state of nature is misleading or tricky in a way, but if you don't like the Achilles appropriate, I didn't say appropriating all the apples in the tree. I say takes all the apples in the tree. Take is a fact, it's not normative. Achilles is not claiming the state of nature, couldn't claim this is mine because there is no property. But if you don't like that example, because Achilles will have to take one apple at a time, suppose Achilles one night takes 2 apples, hides them, and burns the rest of the tree. So Hector wakes up and says, where is the tree? Where am I going to eat? Nothing, you're going to starve. I had 2 apples. Once you die, I will eat 2 apples, and then I will die. Is that morally permissible in the state of nature? I don't think it is. I think it is respectful to the fact that there is another person that deserves some, well, respect, of course. This is the point, that Achilles cannot do wherever he wants unless, as long as he doesn't touch Hector. His duties, his moral duties go beyond that, way beyond that. Touching him is a starting point. Do not touch me without my consent, okay? Granted, but it's the only thing you owe me. No, you owe me much more things. For example, not determining my death just for fun. Not manipulating the context so I will die just for fun. Who can defend? I don't think Kant would defend such a view of the state of nature. He would say, this is incompatible with taking people seriously as persons with worth, intrinsic value, and not just as things. And regarding the possible proposal, I don't think private law would be humiliating. And so 2 things that you say are related. I think of crafting rules of private law in the legislative stage that do not require one-to-one consideration. Is he old enough for me to grant him a special prize? No. You have a rule. And the rule is that if you are above 65, you get that discount. For example, think of mandatory warranty in consumers law. In Spain, in Europe, I think it is. I think it is in Europe, but at least in Spain, For a mobile, you have 3 years warranty. Mandatory, 3 years. A mobile now, how much, how long does it last? 4 years, 5 years? It covers almost the whole term of the usability of the object. This has redistributive effects a lot. And I have another paper in which I show that at the beginning, most businessmen and enterprises say, no, this kind of warranties, mandatory warranties, are bad for consumers because the price will go high. These are all excuses. But they didn't want just to pay to replace the defective units, etc. But after some time, they start appreciating the benefits of warranty, mandatory warranty, because it was an efficient sort of information. People come with the mobiles, you can see how they fail, why they fail, you can repair them, you can improve your product, make it more competitive in the market. So it is efficient, and it also has a very strong redistributive effect, because wealthy people, when after 2 years and a half suffer some problem with the mobile, they buy another one. The people that most claims file to get the warranty are the poor people. So prices do not increase as much as if you buy a private insurance. And this is redistributive because we all pay the same prices because of market price, but we not all benefit the same from warranty. It's rule. Poor people benefit more than rich people. This is a redistributive effect. Suppose the legislator had this effect in mind. Will he be doing something completely misleading, distorting private law? Not at all. There is a clear rule. If you sell mobiles, you will have to do that. There's no judgment about whether your customer is poor or rich. There is no place for that kind of considerations in the proposal I made. I'm just saying that private law rules can have distributive effects, can be used to get distributive effects, and of course, some private law rules can have distributive effects that will destroy the equality that the parties deserve in private interactions. Of course. If you impose some mandatory terms according to which I'm almost your slave in terms of I have to make sure that you are always happy, that you are always well, that your children are well. This is completely absurd, but I'm not talking about this kind of proposal. There is a limit, of course, and it's difficult to draw the line. But the difficulties in drawing the line doesn't mean that you should disregard the distributive effects, consider that do not belong within the private law discourse. Okay, and finally, you said that I'm moving everything to private law. Now everything to private law. Just I'm getting private law into the game. This is the only thing I'm trying to do. Thank you.
I'll try not to monopolize. But consumer protection, we've actually talked about before, and there's nothing inconsistent in it with the content picture. But my worry about framing it in terms of distributive justice, and this is a general worry about trying to say, oh, well, we'll get rid of this problem. They're too difficult. The first is, it only helps if your phone breaks down. That is, private law only interacts at the level of some kind of transaction. And if you're trying to deal with widespread, genuine problems of distributive justice, such as the wide gap in most liberal democracies now between the top 1% and especially the bottom, say 20% in income and wealth, the fact that if somebody's phone breaks, you're transferring a little bit of money from the 1% to that bottom 25%, that looks pretty incremental. But the other problem, and so you need to wait for a transaction because it's only if the phone breaks, or it's only if this happens, or if it's only if that happens. But the other problem is that the problems that you identify with what you mischaracterized as the distributive justice view apply here too. First, you can put it into legislation. Yeah, and then there's a new government and they change the legislation. no more phone warranties. You have this picture where it's somehow subordinating for the way your life goes to depend on the political process. And then you say, oh, well, the political process should produce this output. Your life still depends on whether the political process produces the relevant question. Second, it produces the output. So now you have the poor person has this saving of a couple €100 because they have a warranty on their phone and they go to the shop. And now the shopkeeper charges them unjust terms on the thing that they buy, which was the other thing you complained about. It seems that they can still do that. They can still be overcharged. And so it seems to me that all saying, oh, well, of course, I know you're responsible, we'll have a rule for that transaction too. But again, having consumer protection law, that's completely consistent with the content picture. Because the content picture is a picture that explains how it is that it can be acceptable for how your life goes to depend on decisions of public officials acting in a public capacity, even though it is not acceptable for you to be subject to the choice of a private person. That's the whole point of the content picture. The content picture does not start with a picture of private law and then say, what do we need to add to it? It starts with the question, how is it that positive law, which is positive in the sense of being chosen, could have gone differently? Different government, different judge deciding your case, different members of the jury. How is it that that can still be binding? And the answer is, if it is public in the right sense. But that means that you can put in consumer protection law, including at the other end. But you can't free it from that kind of contingency. If your worry is about the contingency of a different government making a different law, telling the government, oh, make a law about private interactions, that's not a solution to the problem that worries you. And it doesn't make the problem go away of some people depending on other people's private choice. Only a robust public sphere, which has the powers of the content state, which include discretionary powers and include the power of voters to remove a government, even when the government is doing a good job. One instead say, no, but what you should really do is look at what the needs are, and then, here's advice to the ideal legislator. That's not what philosophy does. I'll stop.
Thank you. I think that the three things I want to make clear about, because you say a lot of things, and it's very difficult to.
No, I say only one.
Different ways. I think if I got you right, one accusation is private law can have only modest results in the distributive justice goal. But I'm giving one example. The redistributive effects are all over the place. When you add warranty, standards of care that can be higher or lower depending on the kind of collectives involved in the kind of interactions. Information duties. For example, in Europe, producers of financial products have the duty not only to inform, to advise, and to judge, and they're liable if they make them liable if they make a wrong judgment about the kind of laws that you can take, considering your situation. So the person has a duty that is very demanding. He has to know you well, your personality, whether you have children or not, what age are they, etc., etc., etc. All this is very important because it transfers two things. Since the other party has the duty to provide the information, this is getting information for free. If not for that duty, I would have to pay an advisor. Tell me about which product should I buy, financial product. You have to pay an advisor. So someone is spending money to make sure that I get information and I'm getting it for free. you can say, okay, let's rule out that. Then it's my money that has to be spent in order for you to make business. So there's no neutrality. And there is no modesty in the results once you consider the aggregate of billions of consumers every day taking or benefiting from information duties, warranties, standard of care, and also liabilities. Strict liability, law and economics taught us, have the same incentives in terms of taking precautions. If I'm strictly liable, we take the same precautions. I will do something else like investing in research and development to reduce risk. I will do more things, but in terms of precautions, you will be safe of taking your own precautions to prevent my harm. So it's not money out of your pocket, it's money out of my pocket. But even if the risk is materialized, then some more money out of my pocket will go to your pocket. So this is all redistributed. It's impossible to prevent someone from benefiting or not from these rules. Once you consider all the rules, all these effects, and the billions of people that have interactions every day, I don't think that the results are modest. And I don't think that the preventive effects are modest. When strict liability was introduced, it was introduced because there were a lot of lawful risks that start hurting, for example, workers. They say, okay, we have to do something about this. It's unfair that we're making a lot of money and the people suffering from lawful risks, but I would say completely legitimate activities that should not be stopped. Well, the thing is that the burdens and benefits of the activity are not well distributed. So the best explanation of strict liability, at least in continental systems, has a distributed root. We were seeing that there was a lot of working men suffering the consequences of our capitalist system. You say, no, stop. We should make some transferences, not through the public law, through public law, through private law. Why not through public law? Well, public law has its own problems. Some of them I commented here. And here I'm linking with the second, that is the inefficacy. I thought, they say, okay, private law might be inefficacious. Private law can be inefficacious, is that? Inefficacy? Ineffective. Thank you. Can be ineffective. And also for public law. I impose a mandatory warranty, so you put higher prices. I impose you tax, and you pass it on prices. The effect is the same, but it is contingent. And this plays both for private law and for public law. It is contingent. That depends on the slope of the demand, whether it's elastic or inelastic demand, and also on the offer. There are many considerations that say, look, you cannot say in advance that private law is going to be ineffective and public law is going to be effective. It's contingent, depends on empirical studies. So we should take into account all the effects of private law and public law and try to get the best combination. Yeah. And finally, the change in legislation, the idea that, okay, welfare programs change from government to government, this is unstable. Do you want the same for private law? To be, no, private law tend to be more stable. Actually, tell me, in your country, in the United States, or in any country, how many new policies you know to solve the problem of poverty? You have several policies for each government. They assess, reassess, they go back, they reinstore an old policy. It's a mess. It's a mess. And people cannot depend on that mess. Instead, in private law, all the changes have endured, this one, have lasted. When strict liability was installed, never went back. When information duties or consumer law tried to get better distributed results, it stayed. Because governments know they cannot play with private law in the same way that they play with public law, because private law regulates our everyday interactions. So you cannot change the rules of the game in the middle of the game all the time. So there is, I think, a political constraint, at least some legal conscience about, okay, we can play with public law, change our policies when they are shown to be ineffective, but you cannot do the same with private law. And I think this is a historical fact. You can check it and show me, look, in this country, yes, but in most countries, what happens when you introduce a rule that is fair, it stays. At least this is my view. But we continue, sure.
Waiting here. I'm very, very sympathetic. I want to suggest maybe you want to go along a certain kind of line. It's very difficult to figure out the best word here. Partly it seems like localized distributive justice, or maybe with respect to tort, the core thing is the distribution of the right to the integrity of one's person, although some of the things you're talking about go beyond that. It isn't sort of society-wide distributive justice that is really at play here. Another thought of just where to start from is there are things in private law and its Toronto-Kantian interpretation that lead people to associate it with libertarianism, though there are also as well recognized differences. But in some ways, for your purposes, it might be useful to start with libertarianism, and then I have a thought of how it might develop. Because one thing about libertarianism in private law, there aren't many people articulating it these days, but it has been articulated in the United States. Nozick has one chapter in Anarchy, State, and Utopia, which is quite brilliant, and Epstein has written enough that there's a clear view. And the way libertarianism goes is it prefers property and contract to tort whenever possible. It wants tort to shrink to the domain of interactions between strangers who don't have any kind of pre-existing contractual, that's why they're strangers, they don't have pre-existing contractual relations. There isn't some kind of property relation. If you have a property relation or a contractual relation, then tort should cede the field to property or contract. And that has distributive effects in the accumulation of transactions over time, because in a market economy, just think of the way a contract works, your bargaining power depends on what the resources you have, and property is a fundamental kind of resource. So if you favor property and contract over tort, particularly over time, you favor a world in which the rights of people who have more stuff, simply they come to have better rights. And the contrary view, and it really is a piece of American political history, partly because, or legal history, partly because the United States has always had a weak welfare state, and as a result, it has private law doing things that private law doesn't really do in other countries, from what I can tell. But to take one example is to take product liability law and focus on Henningsen, because Henningsen is the case that says there can be no, you really can't disclaim, it leaves a little opening, but it's very hard to get through the warranty, implied warranty of merchantability with respect to accidents that put physical harm. And you just can't disclaim it. And it's responding to a world in which manufacturers had responded to Buick v. McPherson by standard form contracts of adhesion that restricted the rights of purchasers of automobiles to, if you have an accident and it's a defective part, just ship the part back to us and re-examine it and agree with you it's defective, we'll replace it. And that's how contract bargaining works in a mass economy. There's literature on that after law, from the race to the bottom. Strict liability just stops the race to the bottom, and it gives a more powerful right to product safety to a consumer. And what it does, but libertarians don't like that because it expands tort at the expense of contract. And it will have a distributive effect, or have an effect of making the tort right more effective. And the same thing as you touched on workers' compensation has been widely understood in American law, I think generally correct, but not always correct, that strict enterprise liability, of which workers' compensation is, and primary instantiation, is more protective of the safety of workers and consumers than fault liability. And it's more protective because it insists that the institution or activity responsible for imposing the risk bear it and disperse it, and that protects the participants in the enterprise, particularly the more exposure you are to harm, the more protection you get from it. And that very much migrated in instrumental dimension, so there was a powerful component of it in the last 50 years. It's probably been Calabrese, but as argued repeatedly, it has a non-instrumental thing. And I think it's consistent with your view, it has a distributive effect. And a third one where it's an example, it's not entirely clear how you adjust private law for it, but hot example in the United States at the moment is damages. And damages are a concern of yours because of the way they work with poor person and rich person in auto accident. Well, that's a general problem in damages, and it's notable that sort of statutory schemes of enterprise liability tend to restrict damages so that they require people who are richer to take out private insurance against it. It's more difficult, of course, to do anything like that, but it is consistent with the logic of what you want to restructure damages in that way. And the particular one that is a hot topic in the United States at the moment is the way in which the use of standard damage tables reproduces race and gender injustice, because income distribution in the United States, wage and property, it reproduces historic race and gender injustice, so that if you take simply tables, what you do is when you award damages and you're attempting to follow the purely private law norm of putting people in as good a position as they would have been had the accident not happened, you will reproduce wage and gender injustice going forward. And that seems to me to be a case that does pose a problem for a view like Arthur's, because it's a case where there's more going on in the damage table than just the interaction between the parties. That is the background of basic structure of society, and injustice is in it. Whichever way you go on this, you're taking a position on the relation of background justice to foreground justice. And some adjustment of those rules seems to be the appropriate response for distributive justice and gender and racial justice reasons. And I think that is the place that Arthur might disagree. Wow, we got to disagree. That where the view, the Toronto Kantian view of tort is strictly about the interaction between the parties. One doesn't describe what's going on. It's background justice affecting the determination of the damages owed, and where you really have to conceptualize it more systematically in order to do justice, and what you're doing is some kind of distributive justice and some kind of justice that rectifies past systemic injustice.
Hey, thank you, Greg. Also, lot of things. We'll focus on 5 or 4.
Yes, sorry.
No, about the libertarians. In the first draft of the book I'm writing, I had a chapter on the libertarians, but then I got tired. I got tired discussing with people that are so obtuse. I mean, I used to respect them a lot, but lately I cannot do it. I'm sorry. But I love reading notes. It's a fantastic mind. And the book is enjoyable as opposed to reading Rawls that is not always enjoyable, but he's right.
Right has a lot of virtue.
Yeah. But about the libertarians, I wonder in which sense you say that according to them, property and contracts is preferable to torts, because in just said like that, I agree. Contract solution, it is better. The problem with libertarians is that you can bargain without constraints. But within a constraint, in my own view, property, you have some rights, I have 3 years warranty. Okay, what do you give me in order to give up that? I agree on that, and then I take my chances, not until I'm liberal. I mean, this is the liberal proposal. So, well, maybe I will need to understand a little better what you mean by.
I think it's Epstein is where you find that. Look at Epstein on product liability law or Epstein on landowner duties to entrance onto property, you see the structure of the position.
Oh, it's,
And
I understand.
Epstein's are like.
No, I understand libertarian point of view, and I think is that's sensitive. The problem is the framework in which they make that suggestion. What would you say in general? Is better people to agree and trade or to repair? Well, it's much better to agree and trade. In general,
Right. But then you could
within a
say-
framework.
But then you could say the Henningsen framework is regulated contract, not not freedom of contract as libertarians.
No, because Henningsen involves something that cannot be traded, personal security. It's like selling kidneys. Well, you're not allowed to sell kidneys. I favor contracts, but not any contract independently of what is the object of the contract. About enterprise liability, yes, I agree, completely agree on that. I'm not going to, we discussed in the workshop your book 2 months ago about enterprise liability a lot. We have some minor differences, but as I told you, in general, I'm sympathetic, and it's also a good example. In continental systems, what happened is not the creation of such a thing as enterprise liability in general, we say, it is a strict liability. And there's some conditions, but the kind of reason is more or less the same. We also know that when you have strict liability, or it is unwise to impose strict liability if the law of the big numbers is not there, because you cannot buy insurance, and I think we agree. About damages, this is very, very important, I think also. Our friend Sahi Karen-Pat has done a lot of work there and suggesting, and some of his suggestions are, I think, feasible. Some of them are radical, as he puts it. Said, okay, this is a radical suggestion. Everyone can be compensated by the average loss, or well, this is more difficult to do. But I understand that in damages, there is some room to make this restrictive policy. I will give this example. In my university, I own a workers' man car, Seat Arona, very simple car, 20,000 euros car. That's it. My colleague in the commercial law department owns a Tesla, and we park next to each other. And I'm always the same. When I'm parking, I'm taking extra care, because if I touch his car, my insurance will charge me a lot next year, because representatives. So whose fault is? If you have a car like mine, the harm, the injury wouldn't be that severe. But you're charging it on me. Who should be responsible? Maybe if you are going with something really, really expensive, you have a Rolls Royce, well, you have to take your own losses, buy your own insurance, as you suggest. I don't see there any conflict between interpersonal respect. Respect me. The fact that you bring this expensive car brings a risk on me, a financial risk. If you have a less expensive car or your own insurance, we will be fine. We will relate to each other in a respectful way. But now you're saying, look, my expensive car, don't touch it. Now I have to restrict my freedom to protect your expensive car. Why is that so? So in remedies, I think that we can take real limitations of what compensation you get in certain kind of injuries. I think we can make some policy, but I'm not suggesting that. This is not one of my proposals, but I think that Sahi there has a point, strong. Regarding damages tables, this is here in Colombia also a very important problem. And in my view, tables are important when you have irreparable harm, which by definition is not only difficult to quantify, it's just sometimes arbitrary the quantification is arbitrary. There is no restitutio ad integrum here. It's not something that we can be restored. So, which is the room for public policy there? Well, there is a room, but I wouldn't abuse of damages tables. I wouldn't abuse. I will try to get which kind of compensation is reasonable, as we discussed in your own presentation yesterday. What is the purpose of damages in those kind of cases? Give you means to pursue a new life. Well, then the amount of damages should reflect the severity of the harm, but should also guarantee the continuity of the system, that the system does not break down because of huge amounts of money. And also should be significant in the sense of giving you enough means to reconduct your life to new horizons. These are three constraints, I think. So the limits of public policy should be within that framework. It's not like we can take these tables because we see that 80% of the people are people, very poor people that deserve more. Now we can take the opportunity to give them what they deserve. No, I'm not in favor of that. This should be done through public law. I'm not against using public law. Public law takes probably the most important part of the redistribution problem, but cannot do it alone and cannot do it if private law collaborate. This is the idea. Private law can be a help or a problem. There is nothing in between. It cannot be neutral. This is the point. Can be a help or a problem. On which side are you armed? That's the question. And finally, I think also you are completely right about the background justice. This is when I was writing my dissertation, one thing that I read from your papers, from your early papers. I saw it clear, and this was the key for, I didn't know what to defend. I had a lot of intuitions that everyone that starts with the dissertation, and then I start thinking about how private law constitutes the rights that we have and the background justice. But in terms of, in analytical terms, I would say, okay, you have property rights. I have a property right on this computer. Okay, what are the limits? How much is protected? Because it's fine, I can do whatever, I can exclude you. Okay, fine. What happens if you break it? It's the same if you break it accidentally, if you break it on purpose. Because this seems to vary on the context. I have physical integrity, but if we go, I have a right to physical integrity. What does it mean? I can break your knee in a football match if I'm not doing it on purpose. This is the real physical integrity, right? Physical integrity you have. So tort law is integrated in property law, and everything is together. It's interdependent. You cannot define or tell me what property right I have if you don't consider contract law, tort law, etc. And if property law is a matter of background justice and the two principles of justice apply, then applies also to tort law, because tort law is in part constitutive of the content of the private law. So completely agree. Thank you.
Okay, thank you, Diego, for your presentation and the paper. I think I mentioned before we discussed some aspects. I really enjoyed it. I just want to something different, but actually your answer was about the stability of private law. And I'm thinking, well, this could be a real problem, or at least this means that you will need something else. And so let me explain. So if the private laws are not distributed, you have a real problem. It's need, of course, consensus for private law reform to happen. And I think there is enough evidence that private law reform takes centers, right? So this could be a problem. And this makes me think, well, maybe what you're pointing out is the room that judges have to interpret private, or the room that private law gives judges to interpret private law to be sensitive to distributed concerns when they apply private. And so this probably could be that you have to have an understanding and a theory, or which kind of judges are you talking about, and how you justify this role of judges, because in a way I think maybe this could collapse into that your the issue here is that judges shouldn't be doing corrective justice in these cases, but much more than that. And I'm wondering whether actually it's all about that. Yeah, okay, thank you.
Thank you, Wada. Thank you. I think you're pointing out one of one of the sources of the big disagreement that we might have with Arthur and the Canadian in general. But yeah, because it's
Pay for your school.
as part of common law, they think that private law is about litigation. And in my view, it's completely different thing. Private law starts in legislation. So judges should apply corrective justice, should not make any distributive justice. They just apply the rule according to which if you break, if you harm the neighbor's Tesla, you pay less. They apply the rule. They don't make it in consideration of distributive justice saying, is this really fair considering that Diego now has more money? Well, no, it's not. It's not their role to make these judgments, except in two cases. Except in two cases. So the role of the judge, I'm sympathetic. This is why I like what Arthur writes and what Weinberg writes. I think that they gave a more or less precise, quite precise description about what litigation in private law is about. It's about asserting the rights the parties, and it's about rectifying, it's about, okay, right, that's all right. But the rights of the party are distributive in nature. This is the thesis that they will resist to the end. And second, in which two cases I think that there is room for the judge to make distributive judgments. There are two cases. One, when the legislature says in our civil law, civil codes, there are two provisions that are clear, that clearly require to make distributive considerations. One is ad hoc mitigation. In certain circumstances, you can, for equity reasons, you can reduce the amount of damages. The typical example is two young boys, but legally liable, enter into a stable where there are two horses. They are playing with the kerosene lamp. They want to see the horses, and the kerosene lamp falls. There is a big fire, and the horses are €500 million each. So considering the kind of negligence, considering that they are poor, that they want to be adults, and they will stand 20 floors down their adult life, you can say, I consider that they are insured, because no one in his senses has $500 million in 4 legs without insurance. Considering all that, the judge can reduce it to €10,000, and that's it. And the rest, which will be the difference? The owner will be paid by the insurance, but the insurance cannot recover from the. And this is a distributive justice side, because it's up to the judge to make that decision to reduce and how much to reduce, whether to reduce or not. And it's consistent with corrective justice in a sense, because all the provisions, at least 17 or 18 countries that have this same ad hoc mitigation provision in civil codes. And in all cases, intentional harm is excluded, and even severe negligence is excluded from ad hoc mitigation. So there is a framework in which you can make distributive justice considerations. And the other provision is responsibility for equity reasons. This is for involuntary harms. Suppose someone very, very rich harms who lost his mind, momentarily loses his mind, and harms someone who is really, really poor. The fact that he's lost his mind is not, in principle, in civil law countries, there is no liability for involuntary. Voluntary, I mean, without liberty, without consciousness, in a sense. Well, that does not prevent the judge, if he considers so, to impose liability, which is the most strict kind of liability there is. You pay because you have money, not because you have done, not because you violated rights, because since there is no action, no agency, there is no violation of rights. It's an unfortunate event, but you pay because you have money, and the other one is poor. This is, we have, okay, well, sorry. Yeah, yeah, no, and the second case, I say the second case, just, I don't explain it, I would say, which is legal gaps, inconsistency of rules and indetermination, negligence, duty of care, which is the duty of care, or the standard of care. This kind of determinations can be, in these cases, can be places which distribution justice and Derecho can enter also in adjudication, but it's very limited. Yes. That's the thing, but in principle, limited. The judge, I have the role of the judge making corrective justice. But yeah, it's difficult to give a full reply when Alex is pressing me.
Okay, so thank you, Diego, for an interesting topic, and I'm eager to read the paper. I sympathize with the cause. So, but let me be a little bit of a devil's advocate. So my main question is how we can do it, because I agree that distributed justice should be something to be taken care of. Of private law, I don't think private law should dismiss the distributed kind of justice. But the question, my question is how exactly we do it. Part you answered this like in the last couple of minutes. This, for example, this mechanism, this rule of reduction of damages is it's very exceptional actually. It's like only a few countries that have that rule. Although it's on the principles, so it's European law, so it's interesting. The most of these rules say that this is an exceptional case, right? So, and it's also very controversial, like what's the foundation of that rule? Like some people mention like insolvency problems, for example, like it makes sense. I mean, if the person, obviously to put a judgment on a person who is indebted, completely indebted, it would make sense. You make him pay like $1 million, and he can pay. I mean, it's really good. So it makes sense to make this reduction. I don't know if that's a risk of distributed justice. Some of these rules also mention like there's disproportionate between the harm done and the kind of reprehensible behavior. Like this is the relationship, not necessarily between the condition of the parties. So I'm wondering, like, if we have in private law tools, good tools or better tools than private law to deal with these problems. Like I was thinking in when you mentioned like the hurricane cases and disasters, natural disasters. We have in Chile the tsunami cases in 2010, in which plaintiffs sued the state because the state failed to warn people to when to safe places. They didn't issue the tsunami alert, so many people died. Actually. And the cases are very complicated, and they start questioning, for example, causation, mostly causation, right? So that's a good example of like private law. Is that a better tool to deal with this problem? Because mostly causation, we know that this is a concept very slippery and difficult. So causation probably won't be the better way to deal. So my main concern is like, do we have the tools, or do we need some new tools like this kind of rules of reduction, or something else?
We accumulate them?
Yeah.
Okay,
Waiting.
I hope to remember them later. Sorry.
Thank you, Diego, for the presentation. My question is about the tools of private law to confront this challenge of public or social challenge. For instance, equality, poverty, and distribution. What do you think about reproduction in private law of positive duties or affirmative actions, private law. Which one and when in any area in particular? Thank you.
Thank you, Professor, for sharing your ideas. You have mentioned in another paper, the distributive private law finds meaning only in the standard of compliable framework of interaction. Talking about that kind of framework of interaction, my question is about the nature of the rules governing framework of interaction. Should those rules be public standards or private standards be integrated? Or by the end fact of regulating this kind of framework, should those rules be considered as public standards? I don't know if it's related to this matter, or have in mind those regulatory handbooks. Regulatory sandbox, kind of interactive sandbox regulatories. Sandbox. Those are kind of those kind of sandbox. It's in a space in a real life for testing new products, new innovations, new approaches, without having in mind regulatory or any kind of public forms. Those spaces, those frameworks are temporary.
Family question. It's pretty sure. Don't you think that selfishness is an element essential or definitive in private law? Any great, you cannot eliminate selfishness. You can reduce it. You have to have a power of dispute others to can talk about private. So what is private? There is not a possibility to dispute others.
Thank you. Okay, I will try to do it as fast as I can. Alberto, in respect, I think we have different interpretation about dog litigation, because I don't see all these requirements of intentional conduct or misbehavior and proportionality, all that, as the rationale to decide upon litigation. I see it as a constraint. Once you have judged that the misconduct is serious enough, there is no room for about litigation. Once you have verified that, well, this is all routinary negligent and mislap, then you could apply. You could. It's very exceptional, this rule. And I stick to the traditional interpretation, according to which this is should be applied very in exceptional cases. And most of the legislation say, in exceptional cases, the judge might, this is the European principles of law, in exceptional cases, and you should take seriously what the legislature says, in exceptional cases, not on the regular basis, you're just a Robin Hood here, like get a dog mitigation or whatever. Regarding the other cases, I'm not in favor of playing with the doctrine, like causation to make it other or whatever. Calabresi in the 70s, they had a paper saying, okay, we can use different concepts of causation depending on what we want to reach. The sine qua non is much better to make more people liable than so they don't get that. It's very difficult. In fact, criminal causation is one of the more complex, but at a certain point, I settled with Hart Honoré, Richard Wright version, test nest. This is the conception I'm going to use, and this is the conception I want judges to use. They will solve most of the problems, and they have only a factual view of causation, and then all the other considerations go to the attribution, responsibility, liability problems. So what I'm suggesting, for example, now there is a new rule. This is, I read it on the papers, I haven't read the actual rule, but it's a good example. I don't know how to say in English. This rule norm or this new law about when Derecho al olvido, how is it, the right to forget, right to be forgotten, oncological right to be forgotten. But this is a huge advance. People couldn't get a mortgage because public records said he was an oncological patient. Now he's cured. Now he's willing to pursue his life. Now let's buy a house, go to, no, the mortgage is reduced. This has huge distributive effects for this particular group. Cannot be regarded like, no, this is not important. This kind of laws are not in a way incompatible with corrective justice. I'm not, you can have different views of corrective justice. According to one view, I'm entitled to know what kind of partner are you in our business. So I have to know whether you're a risky partner or not. I'm going to give you a lot of money after all. According to another view, well, this is the kind of information that you cannot have. So even corrective justice, understood in one way, would be in favor of that. But when you consider the distributive effects, this is a second reason, distributive justice reason to support this kind of laws. So not always corrective justice and distributive justice go in opposite directions. Most of the time, the distributive justice effect is supported by corrective justice. Corrective justice. Esteban, about affirmative actions, can you say something similar about this case, this kind of laws? In general, I'm in favor. For example, you have to hire women until you're not allowed to hire more men until your staff is balanced, gender balanced. What kind of restriction is that? There is a case in Argentina, the Privado case, in which they argued, look, we sell ice cream, the cubes of ice cream weigh more than 20 kilos, women cannot lift that. So they said, I don't care. You just have to make the effort and put the women to do something else if it is true that they cannot do it, which is not proven, etc. So I completely in favor, and this kind of decisions, this was a court decision. I find it also, sorry, Supreme Court decision. I find it plausible and useful. Private standards. You should ask Anita. She has an old paper about how communities make standards of care or rules of negligence. I read it a long time ago, but
It's old, it's 21 years old.
I like it a lot, and I'm going to use it soon again. Of course, the rules of interaction are mostly public standards, mostly. But as I argues, it's impossible. It's impossible. It would be impossible for judges or legislators to legislate and to find the optimal rule of interaction for the diversity of communities we have. We have the doctors, we have the merchant people, we have a lot of communities with their own standards. It's much more efficient to pay attention of the standards that they customary have and to then assess them legally, because they might have unreasonable standards. But if they're reasonable, well, you save a lot of transaction cost. And not only, it would be impossible to have negligence law if you not rely in any degree to private standards. They become public after the decision. But up to that moment, they were private standards. I'm going to leave the sandbox question, then we can discuss the further. And finally, Alex, the selfishness. I don't think that private law entails selfishness. Not also altruism as Esteban is too optimistic about the human nature. But I think that this is more the Rosen idea of disinterested. How you say that people that are not disinterested people, like, well, I don't mind whatever you do with your life. I'm not jealous about you. I don't envy you. I'm not concerned only about my affairs. And this is enough. But in any case, redistributive rules, private law, do not require of you any kind of character. They do not require you to be selfish or to be altruist or to be a socialist. No, there are rules. You have to obey them. They require you to be a good citizen and to play by the rules. By the rules because there are rules that apply. Once you follow the rules, if the legislature made all the calculations correct, the distributed justice desired outcome will emerge spontaneously. This is the maybe too idealized, but not as much as wine river idea of revenue.
Thank you very much. Steve.
Thank you. Thank you.
It was, I have prepared some words to close this workshop, but I'm gonna sum up these words. I only want to say thank you to all of you for take the effort, to make the effort to come here from so far around the world. And this is really worth it to organize this kind of event, of academic event. I'm really proud of this network, of this university for organizing this workshop. And I only want to say that you're welcome whenever you want to come here and present your ideas and discuss. Welcome to this university and to this network. This is an open network, and that's the way we want to be a long time. I think this second international workshop provided a rich platform for dialogue and scholarly exchange. The workshop contributed valuable insights to the ongoing discourse on the principles and practices of private law. Moving forward, the perspective and conclusions drawn from this workshop are poised to inform and enrich legal scholarship, and why not, policy making in diverse contexts. Thank you very much. We're going to take lunch.